just saying, it's like, he just, he can't have it.
We're gonna have a hearing on this, we're gonna have a trial. Hey, two choice.
Well, I told you we were gonna.
Well, I'm just telling you, this is a simple case. And no problem, we want to win, we have a trial. If I survive. Great. I'm offering to do a diversion supervised SSC. If you don't want to do that, I'm gonna have to stop. Jerk me around on that space long enough.
That was one who wanted to go to the well.
Yeah, we got the layout. He knew it was gonna look the whole time. Yeah, you know, Santa Monica.
No, it's just a report that came out of the office for so long down here.
Oh,
It's like when we change an environment and then we get the things ready to get in front of the officer ahead of time. And then call them back out. Like, I told them that it was thought to make it right. And I'm like, this is stressful, so I didn't see what people that want to rip it up and work stuff with people about those. And all the things let them know. I was like, I'm trying to say men.
All right. I'm the clerk of court now in session. Honorable Judge David Williams, presiding.
Please bow your head for a moment of silence. Everybody be seated. We have one person transported today, I believe. Who did you transport?
Jonathan Owen.
Okay, it's called Jonathan Owen, Commonwealth versus Jonathan Owen. Commonwealth versus Jonathan Owen, 17 CR 0014, 20 CR 009, 21 CR 00155. Are you Jonathan Owens?
Yes, sir.
Born in 1990?
Yes, sir.
Last four digits of Social Security number 8658.
Yes.
What do you have, Mr. Hurt?
Judge, these are my motions for shock probation regarding Mr. Owens. I'd like to take some brief testimony if the court will permit it from Mr. Garner, who was his former probation officer, and Mr. Owens himself, and I'll be brief.
Okay. You raise your right hand. Who you want to take first?
I'd really take Mr. Garner's, if that's
Okay, if
okay.
y'all move to the right. You raise your right hand, you swear the testimony about to give us the truth, no truth, nothing but the truth.
Do your honor.
Okay, you may proceed, Mr. Hurt.
Mr. Garner, for the record, you state your name.
It's Officer Jeremy Garner, probation and parole.
Okay. As you indicated, you're officer of probation and parole department of Columbia, is that correct?
I am.
Okay. Did you formerly supervise Mr. Owens?
I did.
Okay. How long did you supervise him? Approximately.
I don't have that information in front of me.
If I were to tell you that he was on probation for something like 14 months, does that sound about right to you?
That sounds about right.
Okay. And did you have any issues with him during the period he was on supervised probation?
Aside from the violation that got him revoked, no, I did not have any other issues with him.
That year plus that you supervised, he did not have a single thing, is that correct?
Correct.
Okay. And then sometime shortly after that, he was going to well, you actually moved into unsupervised, is that correct?
I did.
At some point after that, he was charged with DUI, is that correct?
That's correct.
And did he self-report that to you?
I don't have that in front of me.
Okay. You don't recall whether he called you? And
I don't remember how the process
Okay,
initiated.
that's fine. Did you have any issues with him being compliant during your time
I did not.
supervising him?
I had no issues with him.
Did you have any issues up until the new charge to put him back in jail? Any issues with him reporting, anything like that?
I had no issues with him other than the violation.
No question.
Mr. Stockton, when this entered an NCIC, looks like there's an
I believe there
NCIC.
was an entry, we had some either third or
This is one that I remember doing a bond review. Through the phone.
Yeah, it's looking outside the box. No, oh, outside the box.
he was placed in NCIC May 16th, I don't know when he was served.
I was served in court over at Edmonton on the, I think the 26th. Okay.
Does Office of Public Advocacy represent you over there?
Yes, sir. I have an attorney over. I've never had been flown here.
Does the Office of Public Advocacy
Yes, sir.
represent you in
Ye-
Medcalf County?
Yes, sir. Yes, sir. Yeah. Angela Brown, I think.
What are your charges over there?
Felon in possession.
Pardon?
Felon in possession. Felon in possession.
Of a handgun?
Yes, sir. Yeah.
That's the reason that I remember that I kind of had a problem with it when they called me back. I'd set the bond originally, not knowing that, and they called me back and told me that he had charges in Medcalf County of having a weapon. Okay, I'm gonna let you fill out an affidavit. Y'all have an affidavit form over there?
Your Honor, yeah, I come here on 12th, but there was I guess the attorney didn't have time for me, whatever.
Well, it was negotiation day, he
Yeah.
didn't have an attorney, so I didn't speak.
Oh, yes.
Yeah, well, I'm not liking the way all this is looking. I think you're playing the system. You don't need to say anything else. You do an affidavit and you have anything to say about his bond?
I don't think it's sufficient to start. I mean, I'm not following anything. He has appeared in court. That's about all. I know based on my conversations, the victim more likely will have a trial in this case.
You got a form for him?
Good.
Go back in one of those side rooms back there and fill that out and then bring it out and I'll take you up at the end of the docket. Michaela Beatty.
I have two pages, Tyler.
Tyler Beatty.
Your Honor,
Michaela Bailey is 21 CR, come on up. 21 CR 00128. And Miss Bailey, were you born in 1999?
Yes,
For the last 4 digits of social security?
7372.
And are you Tyler Beatty? Okay. This is 21 CR 00127. Year of birth is 1997.
Yes.
Okay. What do we have here, Mr. Stockton?
We have a proposed plea.
What is this? Okay, is this the child abuse case? What, I don't know anything about this case. Tell me something about it.
Well, you had a child that was placed in the physical custody after it was born by a lady that had a drug problem. And then during their care, the child had a broken clavicle, some ribs, I think part of the ribs may have been childbirth, and a skull fracture.
What's the proposed?
Is assault under extreme emotional disturbance, pre-trial diversion.
I'm not going to do a pretrial diversion. No. I mean, I'm going to have to know more about it before I even consider a pretrial diversion.
What would you like us to do to inform you, Judge?
Well, I would say a trial would be the best way to get information about it. And that's probably what we need to do is schedule it for a trial. I cannot really do anything without ex parte in anybody or anything, but I just, these cases where there's serious injuries to children haunt me.
Well, Your Honor, I can tell you that one of the things happened was the child had CPR. They gave it CPR, which gives us an explanation of why we had those broken bones. Secondly, the people who were going to testify that said that there was some abuse, Mr. Stockton and I attempted to get them. We attempted to interview them. They didn't come. He's going to have trouble getting them at trial.
Get a subpoena here in the next day, subpoena on the third.
And they have
What about the medical records?
What about?
Do you have the medical records? What do the medical records indicate?
Basically what I just told you about. In the basic.
What about the concussion? Did they say how old the concussion was or
Well,
anything?
the conclusion of the doctor was, didn't have done from any exercise about it.
Well, I'm not going to take a pretrial diversion on it. So,
I just suggest set one more negotiation day, and if we can come up with something cool, we'll put it out.
well, at least now you know what I'm wanting to look at as far as the thing. I'm wanting to look at the medical explanation of the thing and that sort of thing. What's your next negotiation? Pardon?
16.
You back here on
Your Honor,
September.
I believe that Mr. Harris, Judge Harris, and I have a trial here that day. Special judge. 9, okay. I've got something to 16.
Well,
But anyway,
y'all can,
if I
the
can-
next court date here would be September 22nd. So sometime before September 22nd, if you've got a conflict that day, you can set up a negotiation day, okay?
I'll take it up with Mr. Stockton.
Okay, thank you very much. Donnie Branham.
Good morning, Your Honor.
Good morning. Commonwealth versus Donnie Branham. 18 CR 0069. You are Donnie Branham,
Yes, sir.
born in 1981. Last 4 digits of your social security number 3753.
Yes, Your Honor.
Okay, now I had the DPA listed as his counsel. Are you making an entry of appearance or was that just wrong on?
That is, I think they formerly did. I thought I had filed an interest.
That's okay. That's okay. You can now. It's okay. Okay, what do we got, Mr. Stockton?
Mr. Branham has a motion to revoke probation on a 5-year sentence. He was positive for meth on July 29th of 22. He has a new felony arrest of July the 25th, 22 for DUI and possession. And that's still pending.
Is it a DUI third, fourth?
DUI first.
DUI first,
And
okay.
possession. Controlled substance first.
That's in district court.
That's good.
Okay.
The possession, he's being presented to the grand jury today.
Okay.
So I don't know if you want to try to set a negotiation so we can try to do a global settlement.
I think that might work, Your Honor. I haven't officially been hired on the DUI or on the,
Well, you just officially entered an appearance.
Well,
These others.
well, this is on the revocation, but if we could pass it for a negotiation.
September the 16th for negotiation
No.
and September 22nd for the next court date. Now, do you have your driver's license in your possession?
Yes, Your Honor.
Well, I'm not asking for them. I just asked you a question. Now, on a DUI first, you don't usually take the driver's license in district court, but it would appear to me that the DUI would be a violation of his.
He's going to remain out of custody. For some reason, when this revocation came up, there wasn't an arrest warrant issue. If he's going to remain out of custody, I'd ask if one of the conditions of his probation is not to operate any motor vehicle.
It'll be fine, Your Honor.
Okay. Okay, well, let's change his bond to that. Okay. put him under bond. He would, had never been served with this warrant?
I don't know.
Was there a warrant served?
If there's a motion, no.
There's a motion, there was a warrant served, okay. Well. A lot of times there are warrants issued, you know, when they do these things, so. But I'm gonna make it a condition of your bond. I'm gonna put you under bond. I'm gonna do an ROR bond, okay? Just go down and sign it yourself, and one of the conditions of the bond is that you not be driving and that you observe a curfew, go to work, church, or the doctor. And you'll be here negotiation on September 16th, back on September 22nd, okay?
Thank you, Your Honor. I'll go down and
Shelley Crabtree,
I'll go down with him on the bond.
okay? Shelley Crabtree. What do you have? This Commonwealth versus Shelley Crabtree. 22 CR 0068. Are you Shelley Crabtree?
Yes,
What are the last four digits of your social security number
6623,
and your year of birth?
72.
Okay, what do we have here?
Your Honor, we have an agreement for pretrial diversion with a referral to drug court.
Will you step back there?
I got one question.
She has not been assessed, yet.
Here they are. I got it.
Your Honor, well, I've had this problem with drug court. Mr. Murphy could not get in touch with her to get her assessed. And I'm not willing to do a plea until she's assessed and eligible. Otherwise, it's too many people dodging drug court.
Yeah. What's the charge she has?
Possession, Your Honor.
Possession of what?
Oh, I'm sorry, controlled substance. I'm sorry, Your Honor.
Okay, it could be marijuana, it could be a gun, it could be
It's methamphetamine, Your Honor.
what?
Alleged, it was charged as possession of controlled substance first, methamphetamine.
Well, we'll have, you are on the negotiation date. You want her to have finished the drug court evaluation by the negotiation day.
Yes, Your Honor, I'd say Mr. Murphy's here. She can walk right across the hall.
And we'll do that, and then we'll bring her back next month. September 22nd, you know, same conditions bond.
Thank you, Your Honor.
And then you defense counsel here, you just heard Commonwealth make an announcement that in the future, before these, you can have these drug court referrals, they're going to do evaluations first to see if they're eligible. In the past, we had pleas subject to that, and then they'd go over there and people go in and say stuff. Well, I don't have a drug problem. And then, of course, they say they can't let them into drug court then if they don't have a drug problem, and then they have some lesser supervision. Well, that's not going to happen any longer. I think that's a wise decision that the Commonwealth has made for the protection of defendants and the public. So, Lonnie Duval. Commonwealth versus Lonnie Duval, 22 CR 0030. Are you Lonnie Duval?
Yes, sir.
You were born in 1971. Last four digits, social security number 5942. You're here today for a pretrial. What do you have in this case, Mr. Stockton?
I don't know.
Your Honor. Your Honor, this is one that we had been waiting on the lab result to come back. It did finally come back, I think last week. I filed a motion to suppress it. But
Well, why did you wait till it come back before you want to suppress it?
I didn't want to waste the court's time, Your Honor.
If it was clean.
If it came back, if there was nothing to suppress, then there was nothing to suppress.
Yeah.
So now we have something to suppress, Your Honor. I gave Mr. Stockton his copy of the motion today, Your Honor. I do apologize for the late filing. It was based on the test.
I don't need to see it. Y'all just go ahead and have your hearing without me here. What did the report say?
It was methamphetamine, I believe.
The basis of the suppression motion is the dog sniff, Your Honor. I didn't,
Is what?
is the dog sniff, the canine deployment in this case.
The
I-
dog sniff.
Yes,
Take your
sir.
mask off. I can't hardly.
Sorry. I didn't expect the court to be able to have a hearing today, and I apologize for my lateness of filing the motion. I requested it be set for September or any day that is
Well, of
more
course,
convenient
obviously
for
he
the
doesn't
court.
have the officer here. It'd be
Ex-
hard to have a hearing without the officer.
Right, Your Honor.
Let's set the hearing for the next rule day, September 22nd, be under the same bond.
Thank you.
File your motion within 5 days today. And any law that you have to back it up. Okay?
Got the most recent cases. I went to the seminar.
The stopwatch thing, yeah. Billy Farley. Billy Farley. Mr. Farley, I look at your affidavit here and I'm going to appoint you a public advocate to represent you. Reserved till later. What it might cost you. You have the right to remain silent. You're here today for the purpose of arraignment. The grand jury of Cumberland County has returned an indictment charging you with flagrant non-support. Mr. Bailey. Counsel, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. Says he owes over $36,000. Okay. You want to negotiations
Yes, Your Honor.
on September 16th, the next court appearance, September 22nd. Signing a reciprocal discovery order, Mr. Farley, that where the Commonwealth will provide the information they have so you can prepare for your defense, okay? Barry Gibson. Commonwealth versus Barry Gibson, 22 CR 0037. Are you Barry Gibson? What's your year of birth, Mr. Gibson?
1969,
And the last 4 digits of your social security number, sir.
9632.
Okay, we're here today for a pretrial conference. What do you have?
Your Honor, we have a plea for a pretrial diversion.
What kind of case is it?
This was he'll be pleading guilty, Your Honor, to possession of a controlled substance and tampering.
Motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Okay, you're gonna have to speak up so the microphone will catch you, okay? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Sir.
Are you the same person named in indictment number 22 CR 0037?
Sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you've been fully informed about your case?
Sir.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel for jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I'm applying range of sentence provided by law. I do not have to accept their recommendation. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to a trial. You understand that? Have Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the terms of the diversion agreement, the charge will be dismissed, pretrial diverted, and you can have them expunged. You understand that?
Yes, sir.
You understand if you do not successfully complete the diversion program, however, you will be brought back to the court and schedule a hearing, and you'd be a convicted felon. You understand that?
Yes, sir.
And that conviction will be used against you in the persistent felony offender law to enhance sentences in the future. You understand that?
Yes, sir.
Mr. Stockton, who's going to present?
Mr. Hunley.
Mr. Hunley will come up. This is the Commonwealth's recommendation, sir. I want you to listen closely, okay?
Mr. Gibson is charged with a variety of charges, Judge, apparently flowing from one incident. The Commonwealth has agreed as part of the plea agreement to dismiss the wanton endangerment and equipment charge, fleeing and evading on foot, no registration plates, possession of paraphernalia, failure to maintain insurance. Upon a plea of guilty to possession of controlled substance in the first degree, the defendant shall receive a sentence of 3 years. Upon a plea of tampering with physical evidence, the defendant shall receive a sentence of 5 years. The two sentences shall run consecutively, concurrently for a total of 5 years. The defendant shall serve 60 days home incarceration with the balance pretrial diverted for 5 years. More importantly, the defendant shall be assessed and follow any recommendation of the social service clinician. I don't think there is any fine to this, is there, Mr. Stockton? The defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained.
Let me inquire about dismissal of the insurance charge. I thought there's some restriction on dismissing insurance charges.
It's not policy not to dismiss it unless they can show proof of insurance at the time of the incident.
He did do that?
Yeah, it's not.
Okay.
if they-
All right, I just want to make sure. I didn't catch that. Okay. Go ahead.
The defendant shall remain on active supervision until any and all fines of court costs are paid, until further orders and until further request of probation and parole.
Okay, what are the court costs in this case?
$215.
$215. Is this pretrial diversion what you agreed to?
Sir.
Is that your signature on the document there?
Sir.
Mr. Bailiff, will you recover that? You need some time.
Right.
To pay okay, you can pay it at $40 a month. $40 a month, 215 is the total. Okay, is that correct? 215 is the total? The first payment due 30 days from today. I'm gonna go ahead and, what, has he served in-home incarceration yet?
No, he'll need to get hooked up today, Your Honor.
Okay.
But Mr. Stockton did agree that he could go to work while on home incarceration help pay for it.
Who's Mr. Smith hooking people up? Is that what it does it? You have a number for him? Well, we need to make arrangements before he leaves the courthouse.
Okay.
Can you help him, Mr. Smith, or who does that?
I'm called.
Okay, if you call Mr. Smith and tell him that this gentleman's waiting. Okay,
Your Honor.
Brian Hawkins. I'm going to take a verse from Brian Hawkins, 22 CR 0072. Are you Brian Hawkins?
Yes, sir.
Mr. Hawkins, what is your year of birth?
329 and 69,
Last four digits, social security number?
8056.
Okay, you're here today for a pretrial conference. What do you have?
We have a felony plea, Your Honor.
Motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 22 CR 0072?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with her advice?
Yes,
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial, but jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose. And the right to require the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. Understand by entering this guilty plea today, you give up those charges. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
Yes, sir.
What is the recommendation in this case?
Your Honor, upon a felony plea, possession of controlled substance, first degree.
The defendant shall receive a sentence of 3 years. He'll serve 90 days home incarceration, ankle monitor, probated for 5 years. He'll pay court costs discretion of the court. Obtain gainful employment, and all evidence in this case be destroyed.
So there's no immediate incarceration in it?
No, Your Honor, it's second go around on imposing home incarceration. Evidently,
Okay. Is that your understanding of the Commonwealth's offer?
Yes, sir.
Are you pleading guilty because you committed the act charged in the indictment as amended?
Yes, sir.
Plead guilty of your own free will?
Yes, sir.
Knowing your constitutional rights to explain to us as to your desire to give up those rights and allow the court to fix your punishment. You understand that by entering a plea in this case, any future convictions can be enhanced as far as your range of penalty under persistent felony law.
Yes, sir.
Is that your signature?
Yes, sir.
Okay, I'll accept the agreement subject to review the pre-sentence investigation report. You come back here on September 22nd for sentencing. Now, Mr. Stockton, if he's going to do in-home incarceration on an ankle monitor, he needs to sign up today, because if he wasn't doing that, I'd send him to jail. So you need to get the number of the company that provides the services, and before you leave the courthouse, you need to make arrangements for them to put the ankle monitor on you today. Okay.
Yes, sir.
Okay, could somebody give him that number?
I have it.
You do?
Yes, sir.
But you got it, you got the monitor on now?
No, I do not.
No, you've had it on before.
Yes, sir.
A repeat customer, can't beat those, you know. Okay, thank you very much.
Thank you, sir.
James Hurst.
Shively, Your Honor. Dawn McCauley is the attorney in this case. She has asked me to request the court for.
Well, let me get him in front of me first here, okay, and then we'll get to you, all right? Commonwealth versus James Hurst, 22 CR 0013 and 22 CR 0038. You are James Hurst?
Yes, sir.
Born in 1970?
Yes, sir.
Last four digits of your social security number are 2119.
Yes.
Now, you want to come over now and say your piece here?
Dawn McCauley was appointed as counsel. She is in the middle of a trial in front of Judge Spalding that was supposed to be done yesterday. She's asked me to ask the court to allow this to be continued to the next hearing date.
What's the charge, Mr. Stockton?
He has trafficking and controlled substance over 2 grams and 22 CR 38, 22 CR 13 theft unlawful taking a motor vehicle. I have an offer on the table with Ms. Mccollum, and she can't be here on the 16th negotiation day, so she needs to get with me before the next court.
She can't be here on the 16th.
According to Mr. Chadwick.
She has asked me to avoid the week of the 13th because she has a murder trial. She didn't say anything about the 16th particularly.
Maybe she'll just brush that murder trial along here. take care of this charge here.
I think the
She'll be here
16th
on,
might-
she should be here on the 16th for negotiations. If for some reason she can't be here on the 16th, she needs to contact the Commonwealth Attorney's Office to set another date. Sir, you shall be here on the 16th unless otherwise advised by your attorney. And you'll be back here on September 22nd. Okay? 1 o'clock and the 22nd is at 9 or as soon as you may be heard. Okay? Yes, sir.
Judge, are we setting both those dates today? So I should let her know of both.
Okay, let me go over it again. He should be here at the 16th at 1 p.m. for negotiations. And he'll be here on September 22nd
Thank you, Your Honor.
for his appearance. Both of those are a condition of his bond. He doesn't have to be here on the 16th if his attorney says she can't be there on the 16th and has another negotiation day before the 22nd. You understand me?
Yes,
Okay, thank you. Commonwealth versus Jennifer Key. Jennifer Key, it says active warrant.
You can see, I see.
Okay. Kern Cost,
Here's another one that just, it's done.
Caitlin Lawson. Commonwealth versus Caitlin Lawson, 22 CR 0060. Are you Caitlin Lawson?
Yes, sir.
Okay, you're here today for a pretrial conference. What do you have?
Your Honor, Ms. Lawson is a co-defendant with 5 other people, or I'm sorry, with 4 other people. We have been working on getting conflict counsel. We do not have it in place yet. I've
What's
kept
this
Mr.
case
Stockton
about,
apprised.
Mr. Stockton?
It's a threat case, Your Honor.
How many times has she appeared here?
This is the first pretrial, Your Honor.
Yeah. You have conflict counsel for everybody else?
No, Your Honor, we are still trying to get everybody lined out. It's complicated. I apologize to the court.
What did you ask them if they're willing to sign waivers of multiple representation?
They are willing to, some people are willing to sign with some and some aren't willing to sign with others. So they're in groups. And so we're trying to work it that way.
Let's just set them off for the 22nd, so they can appear with counsel. It's like 5 of them.
Yeah, there are. I'm hopeful that we'll
Well, I
have.
want
an attorney-
counsel appointed and have them here on the 16th for negotiation.
Oh,
Mr. Stockton, I'm scheduling them to be here on the 16th with counsel for negotiation. Okay, and then the next court appearance will be the 22nd. If you're having trouble getting someone appointed, you need to notify the Commonwealth Attorney, and then both of you can contact me. So we cannot allow these things to languish.
I understand, Your
Okay,
Honor.
okay. Michael Nethery,
Matt,
that's just a forfeiture thing on Michael Nethery. There's no objection. Jared Norris, Commonwealth Kentucky versus Jared Norris, 20 CR 0069. Are you Jared Norris?
Yes, sir.
Born in 1986.
Yes,
The last 4 digits, your social security number are 8168. You're here for pretrial conference. What, you got anything on this?
Yes, Your Honor, we have a felony plea.
A motion has been tendered. Mr. Norris says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is the plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22 CR 0069?
Yes.
Is your judgment impaired today?
No.
Have you discussed these charges with your attorney and are you satisfied with her advice?
Yes, Your Honor.
Have you reviewed the evidence Commonwealth has against you?
I have.
You believe that you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution.
Yes.
Before I can accept a plea, I need to know that you fully understand those rights. You have the right to not testify against yourself. No one can make you say anything. Your right to speak trial, but jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against your right to produce evidence, right to call witnesses to favor, right to appeal this matter to a higher court if you lose, your right to acquire the Commonwealth without a reasonable doubt that you are guilty. You understand by entering a guilty plea today. to give up those rights, and I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I don't have to accept the recommendation. I will await a pre-sentence investigation report before making that, but probation parole and I do not accept the recommendation to set impose harsher sentence. You have the right to draw your plea. Who's presenting the Commonwealth's recommendation? Y'all move to your left, please, there, Mr. Stockton.
Mr. Norris has agreed to plead guilty to receiving stolen property, 3 counts, receive a sentence of 5 years on each to run concurrently for a total of 5 years. He'll also plead guilty to possession of controlled substance, 3-year sentence. All the sentences shall run concurrently for a total of 5 years. Probation to be supervised. He's to be evaluated by the SSC, follow all recommendations, maintain his gainful employment, forfeit all interest in any personal property seized during the investigation. All drug paraphernalia will be destroyed.
What was court cost in this case?
$240.
$240. Okay, is the recommendation just stated by the Commonwealth what you agreed to?
Yes.
Okay. Are you pleading guilty because you are guilty of the act charging the indictment as amended?
Yes, Your Honor.
You do so of your own free will?
Yes.
You know, the rights explained to you that see your desire to proceed with the plea.
Yes.
Okay, you understand that after entering the guilty plea, as I said previously, any future convictions will be enhanced in a persistent felony offender law. Is that your signature on there?
Yes, Your Honor.
Okay, now, there's no ankle bracelet or anything on, it's a straight probation.
No, he wore an ankle bracelet for a long time. He was open in the arms.
Yeah, so, but there's no further need. Well, I will accept the plea. Well, schedule your sentence on September 22nd. Court costs are $240. I would assume you need some time to pay that.
Yes, Your Honor.
So you make your first payment of $40, 30 days from today, and $40 every day after that. Should be 6 months or so. It'll take you, spread it out to give you an opportunity to meet with probation parole officer. That's your signature on the document there.
It is, Your Honor.
Okay, we meet the probation parole officer be here on September 22nd.
Thank you.
Robert Purdue.
Your Honor, we've got plea on that case, but there's one little kink regarding no insurance, and
Where is your client?
I asked him. I had him step outside to make a phone call. We're trying to establish that there was valid insurance on the vehicle at the time of the stop. There was, but Mr. Stockton's office has been told that Mr. Purdue was not authorized, so I've asked him to step out and see if we could clarify that. Other than that, we're ready to go.
This issue could be resolved this morning. We either put it out next month for a plea or set a trial date or whatever.
Well, I mean, we're settled, except he had insurance, but they said he didn't.
I don't know for what company.
Well, I understand. He's trying to get, I had him call the agent. We'll see what.
What agent is it?
My point is this, regardless of what he calls, or says, I'm not gonna believe what he says. I'm gonna believe the insurance.
Well,
So I'm gonna have to have some proof.
well, I understand, but if he calls, we'll get through.
Well, maybe.
Hopefully.
What insurance company is
Shelter, I think.
I forget. It was a commercial vehicle. They had insurance.
They probably didn't have him listed as a driver.
That's what it is apparently, but if it's a commercial company, it's covered anyway.
But I get these all the time, whether it's restriction or no insurance, or there's always a problem, so we always call and verify.
If you'll just give us a few minutes, we'll.
I'll give you till September 22nd. That's even better.
That's fine. Okay.
Yeah. Okay, Eddie Scott has not been served. Mr. Eddie Scott has not been served, Mr. Stockton. Stacy Shelley. Cromwell versus Stacy Shelley, 21 CR 00156. Are you Stacy Shelley?
Yes, sir.
You born in 1981?
Yes,
For the last 4 digits of Social Security number.
3557.
We're here for pretrial conference. What we have? Mr. Stockton.
I don't know, Your Honor, with all the confusion, if the plea was ever entered in this case or not.
We had a plea and we were going to be finally sentenced, and that's when basically the breakdown came. Of course, for calls, and she's been out and still having some issues, but
got good family support, her family's here. I don't know if we want to enter a plea today or you want to pass it 30 more days. Whatever the court
I'm prepared to
prefers.
stand by my plea if she wants.
Do what?
I'm prepared to stand by my plea if she wants to.
Well, we can soon do it today. The paperwork's been completed.
Yeah, did you have her evaluated by Donta?
She's been to Adonta, and may I approach? May Mr. Stockton and I approach?
Sure. She can come with you.
Yes, that's done.
Go to shopping or do other things like that. Okay.
Thank you.
But when you leave, you need to have somebody with you till we get this. Who from her family's here?
Her dad, Bill Connor, and her sister, Sarah North. They're both.
So now he had to stay, I mean, stay all night. I mean, you know what I mean? Because he's been staying with, we've been staying together one place. I didn't know if I can.
Your mobile home's here, his house is here. Do you want? You
Don't have to be in the same structure.
Okay.
Have him come around. Where's he?
Bill Connor,
Yeah,
you want the sister?
yeah, have a sister
Karen.
come up.
Thank you, Your Honor.
Go wait a second. Oh. Are we still off the record over here? Sutherland. Dustin Sutherland. Commonwealth versus Dustin Sutherland. 21 CR 0035. Are you Dustin Sutherland?
Yes, sir.
Were you born in 1982?
Yes, Your Honor.
Last four digits, social security number 6346.
Yes, Your Honor.
Okay. On a probation revocation, what do you have?
No, this is the case when Mr. Sutherland, he's got a 5-year sentence for trafficking. Evidently, he had an episode in Trimble County with his girlfriend and her daughter.
Drop your mask on too.
and where he was allegedly drinking. I was able to speak with the probation officer that was supervising yesterday. And she said, other than this, he's had no violation. She said if he is convicted of this, she would probably move for revocation on this. And I proceed. I can call the officer as a witness next month if you want to have a hearing on it, or we can see how it works out
So it's in district court up there?
in Trimble County. Yes.
Okay, let's put this off to September 22nd and see what you can work out up there, okay? You need to live at the foot of the cross. Hey, I'm talking to your client still, okay? You need to live at the foot of the cross between now and then. Don't need to be getting anything else. You understand what I'm saying? Okay.
Your Honor, I think the case in Trimble County comes back October 4th.
Yes.
Do you still want to see?
October 27th then, Mr.
Okay.
Stockton, October 27th. He's not being back in Trimble County to the first part of October 27th.
Thank you, Your Honor.
Dylan Weaver. Como versus Dylan Weaver, 22 CR 0060, 65. Are you Dylan Weaver? What are the last four digits of your social security number
5750
and your year of birth?
122.
You're here for purpose of arraignment. Do you have an attorney?
With the public.
Okay.
He represented him downstairs, Your Honor.
Yeah, I see.
Or, well, I
See
guess
his
thank you.
affidavits are record also. The grand jury of Cumberland County's returned an indictment charging you with trafficking and controlled substance in the first degree. Possession of drug paraphernalia, possession of controlled substance not in the original container. And possession of controlled substance in the third degree. You acknowledge the identity of your client, proceed indictment, await formal reading or arraignment, enter plea of not guilty, reserving all pretrial motion.
Yes, Your Honor.
I'm signing a reciprocal discovery order. Now that where your attorney will get evidence that the Commonwealth has, you'll be here on the 16th for negotiation day, and your next trial date is on the 22nd. 16th.
Sorry, I have a court in Allen County on the 22nd at 9 a.m. for a traffic violation.
What's that for?
It's for driving with no proof of insurance.
Okay, will you be here as soon as you can after you get it finished with that, okay?
Okay.
Here on September 16th, and if you settle it on September 16th and there's gonna be a plea, we might do something else as far as the second date is concerned, okay?
Thank you, Your Honor.
Thank you.
That was Dylan. Dylan. Okay, well, Tammy, there was two Weavers there. You what? Okay, Tammy Weaver. Tammy Weaver. Commonwealth versus Tammy Weaver. 22 CR 0073. Are you Tammy Weaver? Are you Tammy Weaver?
Yes, sir.
Okay, were you born in 1978?
Yes, sir.
It's the last four digits of social security number.
6306.
Okay, and this is 22 CR 0073 pretrial conference. What do you have?
Your Honor, she is, like Ms. Lawson, the co-defendant. She's one of those five. Mr. Weaver, who was just arraigned, is also there. I think I may end up keeping Miss Weaver and Mr. Weaver, but we're still working on that situation.
So you want them back here on September 22nd,
Yeah, well, the 16th and then the 22nd.
16th for negotiations at 1 o'clock and on the 22nd at 9 a.m. Both of them are conditions of your bond, okay? Same thing is true with Dylan. Dylan.
Thank you, Your Honor.
Trey Wright. Oh, versus Trey Wright. 22 CR 0076. You're here for the purpose of arraignment. You need your affidavit, I'll point you. Counsel. You have a right to remain silent. The grand jury, Cumberland County Attorney indictment charge you with theft by deception. You understand that charge? Okay. Acknowledge the identity of your client, receipt indictment, away from reading arraignment, and pleading not guilty or serving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. The Commonwealth's going to give your attorney evidence to help you prepare. I look at your affidavit and you're not working anywhere. Do you have a disability of some sort? Do we all know about?
No, sir.
Why aren't you working?
I was working, but,
I mean, why aren't you working now?
I got a job interview I just went to last night in, Scottsville. It's a Dollar General warehouse. They're supposed to give me a call, I think it's Thursday.
This Thursday?
Yes.
Well, it won't hurt you any if you're working when you come back. You understand? I mean, I had somebody over in row the other day, asked them when they were working. They said, well, they had a job about 3 years ago. I mean, I don't think anything good's going to happen. You got all that spare time on your hands. So you need to come back here. It'll be in your favor to be a worker when you come back. Okay. Okay. And I guess that finishes the docket except for Bronny Bays, right? Is there anybody else alive? Where is Mr. Bays? So you're making $3,300 a month?
Yes, sir. I work for Market Transportation. I work on Mississippi River. I'm going 28, home 14. That's what I've been doing. I make more than that normally if I get a full month. I probably bring home about $5,800 or something like that. But out here lately where I've had court, I barely made it to I got off the boat in time to get to my court date. And I ain't been able to work for like a month and a half. Where this court dates are scheduled and stuff.
Could you look up on CourtNet and see when the gun charge was? If it predates this indictment here.
Oh.
On the gun charge. When was this indictment here? So the gun charge predates this. Well, I don't think you're eligible for the appointment of public defender level of income. I guess I can appoint you one subject to being charged for it. So I'm gonna appoint you a public advocate. I'm gonna charge you $2,500. It's to be paid in full in 90 days. Be here for negotiation day on the 16th in September at 1 o'clock, and next court date is the 22nd at 9 a.m. Both of them conditions your bond. Okay, does that take care of anyone that's here for the criminal docket? We got to go over to the jail docket, but I've got to run down real quickly here to get the indictments from the grand jury. Do we have all of this next page? Where are they at? Derek and if you're with a corrections institution, I'll be with you. We'll start first with Allen County, Barron County, Grayson County, and Hardin County, because y'all just got one each, okay? And I'll be right back up. I've got to go down. What do you got?
I don't know if this is part of your jail docket, but I was also here for Christie Brown. I did not hear her call 22 CR 35.
Part of the jail docket. Thank you. Yeah, I'll be right back. You got something?
We all are.
Here.
Allen County, will you come on? Thank you so very much. Commonwealth Kentucky versus Mary Williamson, 22 CR 0063. Are you Mary Williamson?
Yes, sir.
Born in 1999?
Yes, sir.
Last four digits of social security number
4830.
830, right? 4830. We're here today on a pretrial conference.
Your Honor, I represent Miss Williamson.
Do you have a computer set up?
I do, Your Honor. I was just out here when you called it and I didn't.
Just run back there real
Okay.
quick. There's your attorney, Miss Williamson, Miss Costello on there. What do we have here, Mr. Stockton? Need to put your microphone on, Mr. Stockton.
We have a pretrial conference and I was wanting to wait until after Mr. Cape is sentenced today before we have enters his plea before we deal with her case next month. That's all right with the court.
You want to put her off till next month?
Yeah, if that's all right with Ms. Williams.
Can we go ahead and do mine so I can know?
Miss
Are you-
Williamson, it's in between the two things that we talked about on Friday, and we just need a final answer to that. It's beneficial to you to wait.
Well, I
Okay.
mean, is she gonna have to serve some time anyway?
She's
I mean,
already
yeah.
a state inmate, Your Honor.
Already a state inmate, so this won't cost you any more time.
No,
What they're saying is it would be beneficial to you to get this other thing resolved. If you're already serving time anyways, the state inmate won't cost you any more time, okay? Okay, thank you very much. We'll set this for September the 22nd. And we'll be getting notification if you're still at Allen County, we'll get notification to Allen County. Thank you so very much for your cooperation. You're excused. Barron County. Barron County.
Hello, Your
Barron. How you doing today? This
I'm good, sir.
Yeah, this Commonwealth Kentucky versus Parker Purdue, 22 CR 0061. Are you Parker Purdue?
yes, sir.
Okay, your year of birth 1979. Last four digits, social security number 3571. You represented by Mr. Garrett. We're here for a pretrial conference. Mr. Stockton, what do you have?
Mr. Garrett's filed a motion, Your Honor, in this case.
What do you have, Mr. Garrett?
Judge, it's a competency evaluation. Mr. Purdue had schizophrenia with psychotic features, and so I'm going to be asking him to be evaluated.
Okay, you want KC?
Yeah, I'll do the order the same way I did those others, Judge, and let Dr. Sibley out of Hopkinsville do it. And I'll tender that to you today.
Okay, that'll be fine. When you want to schedule this again? You have any idea what kind of time frame you're talking about?
Judge, I think it'll be a little greater than 30 days if we can set it
Okay,
for the
well, let's put
October.
it on, let's put it on for September 22nd. If it hadn't been done for them, you can sign an agreed order of continuance, okay?
Okay, sure. Thank you, Judge.
That'll be fine, yes. Thank you, Barron County, for your patience. Y'all can be excused.
Thank you, Your Honor.
Grayson County. Grayson County. Grayson County. Mr. Cross, you have Nathan Costello.
Oh, yes, Your Honor.
I need to go out there, Jeremy.
He's supposedly in Grayson County. I don't see Grayson County online.
They're on, they just don't have their camera on.
GCDC, Grayson County Detention Center. Will you turn your microphone and camera on? GCDC. Would you?
I came out here. Mr. Kraus.
He went back out, he's on the camera here.
I came out here so we'd have a hearing. If we need to take Mr. Garner. He's been found competent, and if he doesn't stipulate, I'll put on probation parole as witness.
Okay, there is Mr. Costello. Is on there. Mr. Stockton, I don't know how we're gonna get you on there.
Well, I could have, Mr. Garner come back to the room.
That's what you need to do. Both of y'all go back there. Mr. Cross, I'll just go ahead and recite things for you. Mr. Cross, you have a motion for competency hearing.
Your Honor, we do, and Mr.
Have you seen the
Castillo.
report? Have you seen?
Yes, I have. I have seen the report. I'm unaware if Mr. Castillo has seen it or not because he's moved around on us. I did not know he was in Grayson County. Admittedly, I could have gotten on cool and found out, but I think we'd be prepared to withdraw that motion, Your Honor, based on what we've seen in the report. And we'd like, I know Mr. Castillo would like to get this case resolved and get all this behind him.
Well, you want to set it out for the 16th for negotiation?
Of course, he can't be here. Mr. Stockton and I can discuss it, but I'll have to get with Mr. Castillo.
Well,
Nathan,
they can make arrangements for him
Okay.
to discuss privately with you on a Zoom. Set
Well,
out in chat rooms.
we'll be out the afternoon of the 16th, so I'll have to get with Mr. Stockton after I get with Mr. Castillo. So Nathan, will you be in Grayson County for the foreseeable future?
I believe so, sir.
Okay, I'll call you next week and then I'll get with Mr. Stockton and we'll try to have a resolution by the 22nd.
That'll be fine. Thank you very
Thank you.
much. And thank you, Grayson County Detention Center. Okay, y'all are excused. Hardin County Detention Center. Hardin County Detention Center. And then we will come to Warren. Hardin County Detention Center. Shane Caps, it says Shane Caps on there. Shane Caps.
Shane Caps.
Yes. Are you in the
Hold on,
Hardin County
we went.
Detention Center? Is that correct?
I'm in LaRue County.
You're in LaRue County.
Yes.
Okay. Okay, this is Commonwealth Kentucky versus Shane Caps, 20 CR 0032. Are you Shane Caps?
Yes, sir.
Were you born in 1990?
Yes, sir.
Last four digits, your social security number 3624.
Yes, Your Honor.
Will you put Mr. Costello off? We're finished with Grayson County Detention Center. Need to be turned off.
I can do.
Okay, thank you.
Your Honor, this was my motion for shock probation on behalf of Mr. Capps. Unfortunately, he had another case at the same time in Clinton County, and the charges were ran together, but there was not a motion that was filed in Clinton County, which would make, and he's beyond the time limits in that, so he is ineligible for shock probation there. So even if the court were to grant it here, Mr. Capps unfortunately couldn't be released.
Okay. Are the two running together?
Yes, sir.
Are the two running together?
I believe so, Your Honor. But we did not file the motion in Clinton
Well, what
County.
I'm telling you is I just want to make sure the two were running together.
Yes,
So if they aren't running together, Mr. Stockton, we can make sure they are running together, even though we don't do shock probation. You understand what I'm saying?
Yeah, I think he's parole eligible in November, and I hope he makes
I
it.
just want to make sure, Mr. Capps, that as they say, that one would kill this one. You understand what I'm saying?
Yeah.
Yeah. Okay. Well, thank you. Thank you very much. And you may be excused, Mr. Capps, and thanks for the people who helped get you online there. We appreciate it.
Hey, Your Honor.
Yes.
Your Honor, does that mean I made shock probation or not?
No, what it means is that you were not eligible for shock probation on the charge over in Clinton County.
Mhm.
And even if I gave you shock probation here, you'd still be held on the other one. Okay, and on the Clinton County charge. So what I'm telling you is that I want your attorney and Mr. Stockton to review to make sure that when you finish up with the Clinton County case over there and get paroled or whatever happens, it will apply here too, that the two will run together. So you won't be stuck again where you do one thing in one county and one in the other. You see what I'm saying?
Yes.
On the same page, yeah.
Yes, Your Honor.
Okay.
Can I say something else?
Sure can.
If I was granted the shock probation, I'm almost served out on the other charge in Clinton County, is why I was just wondering.
Yeah.
Because it was 3 and 3 for a total of 6.
Ms. Costello, will you check on making
will.
sure that that's what I'm trying to tell you, is I want this one to be killed by that charge over there. You understand what I'm saying? Whatever it takes to do that.
Okay, thank you, Your Honor.
Okay?
Yeah, and I will, because he's got a job in Hodgensville. Whenever he serves out in Clinton County, I'll do an agreed order where he can
Yeah.
get out and work.
We won't let this case stop you.
Okay, thank you.
Okay, you see what I'm saying? I don't know
Yes,
which
sir.
way the best way to work it out is. If the best way is to shock you on this one, we'll do it. If the best way is to sign an order, run them together, we'll do it, whatever it has to do, okay?
Thank you, Your Honor.
Okay, you have a good day. Warren
You too.
County Detention Center. Warren County Detention,
Andy Metter, I'll need that file.
Randy Metter.
Good morning, Your Honor.
Good morning. This is 19 CR 0078 Commonwealth of Kentucky versus Randy Metter. Mr. Metter, were you born in 1980?
Yes, sir.
Last 4 digits, social security number 2068.
Yes, sir.
It appears to be on a revocation, probation revocation. Mr. Stockton, what do you have to say?
Well, if we are required to have a hearing, I've got Mr. Bray on the line to testify.
Okay, Mr. Bray, are you on there? If you turn your seat on there, if you'll turn your camera on.
Yes, sir, I'm here.
Will you raise your right hand, please? Swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Mr. Stockton, you may proceed.
Mr. Bray, are you familiar with Mr. Metter's cases?
Yes,
Have you been supervising him at some point in time?
I have been.
And when did he begin supervision?
He began supervision with in our system on in another case, but not your case, on looks like July the 3rd, 2018.
Okay.
He's on for several different counties.
At some point in time, did you file a violation report on or about March the 29th, asking that he be revoked?
Yes,
And what was the basis of that revocation violation?
he was convicted of 4 new felony cases in Barron County and sentenced to serve on those cases. And looks like a new misdemeanor case as well.
Okay, and when were those convictions entered?
Conviction, he was convicted on January 3rd of this year in the 4 felonies. In the misdemeanor, he was convicted October 25th, 2021.
Okay, the 4 felonies he was convicted of and sentenced, was he sentenced on January the 3rd?
Yes,
Okay, what were they?
they were Barron County 21 CR 105, 106, 214, and 261.
And what type of cases were they?
105 and 106 were both theft by failure to make required disposition of property. And 214 and 261 were theft by deception, including cold checks under 10,000.
Okay, is Mr. Metter a state prisoner?
He is.
Okay, I have no further questions, Your Honor.
Mr. Costello, would you like to inquire?
Yes, so Officer Bray, you said that the misdemeanor conviction happened in October of 2021, is that correct?
Looks like, yes, it did.
Okay, and the felony convictions were, he was sentenced on January 3rd?
Yes, to all 4 of those.
Okay. Do you know the date that that the allegation occurred that led to those charges?
Well, the charges were, there was allegedly a scam going on eBay. I don't know the exact dates of all the different charges that led to an investigation into which he was finally convicted of all 4 cases. And he has restitution in all 4 cases, but I couldn't tell you the dates of each one of them right offhand.
Okay. So you said that you began supervising in July of 2018 on another case. Is that
Well,
correct?
I actually inherited Mr. Metter's case from another officer that had retired.
Okay.
So I began supervising in July of last year, 2021.
Okay. And he actually entered supervision for Cumberland County in October of 2019. Is that correct?
I believe so.
Okay. So to your knowledge, you don't know if the charges in Barron County actually, the conduct arose prior to that supervision, do you?
Not prior to July of 2021.
Okay. Nothing further, Your Honor.
Just one question on redirect. What was the misdemeanor conviction he was convicted of? Not
The misdemeanor was theft by failure to make required disposition of property.
and you know the date that occurred.
The date, I could look it up, but
Yeah, if you can look it up real quick.
yes,
The
sir.
date of the crime.
Okay. It looks like Mr. Metter was charged on May the 11th,
Of what year?
2021.
Okay, and he was convicted that same year.
He was entered a guilty plea on October 25th of 21.
Okay. You've gotten your one of your violation reports that he was charged in 21F 294 on May the 11th. Was that the same misdemeanor or was that another felony?
That is the misdemeanor, yes, sir.
Okay, that's what I wanted to clarify. I have nothing further, Your Honor.
Ms. Costello, do you have anything else?
Not for this officer, Your Honor.
Okay. Mr. Stocking, you have anyone else you want to call?
No, Your Honor.
You want to make your argument? You want to call anybody, Ms. Costello?
No witnesses, Your Honor.
Okay.
I do have argument for the court, though.
Okay.
I do have a couple questions, Your Honor.
Mr. Metter, please don't say anything. It's not to your best interest.
Well, let him ask the question if he wants to, as long as he doesn't make a statement.
Okay.
Don't make a statement of any fact that can be used against you. You have the right to remain silent. You understand that?
Yes, sir, I do, sir.
Okay, what question do you have?
I'm doing my state time. I have a 5-year sentence that I'm serving out on. And since I've been here, the whole time, they have worked with me to get me into rehab. They have worked with me to get me into a SAP program over my addiction.
Is there a question coming?
Well, yes, sir. I'm just trying. I mean, I'm wanting to go to rehab, and that's what I've been trying to get done. And I finally got it done. That's why I was asking. I wanted to speak to my attorney. I've called her Friday.
Yeah,
and
Mr.
today.
Metter, I was going to add, that's one of the things that I was going to make an argument to the judge about. Okay.
Okay, well, what do you have to say, Mr. Stockton?
Your Honor, this case has been put off, and put off. I've been trying to get Mr. Metter revoked since March. And I don't know if it was the grand strategy to put it off till he could get into rehab or what, but he got 4 new felony convictions in Barron County and a misdemeanor conviction. He should have been revoked back in April. But this case kept getting put off and put off because he wouldn't stipulate. And I just want the case over with. I want him revoked, and then whatever happens, happens.
Okay, Ms. Costello, do you want?
Yes, Your Honor. So the motion was filed, or the special was filed, I should say, by Officer Bray in March of 2022. The allegations actually arose well before that. And we would just argue that for due process, a more timely, and this is not a fault of the Commonwealth Attorney, it is on DOC, which would be to raise these concerns when they, in a timely fashion, when they arose, so that Mr. Metter could come before the court. Now, once it was in court, we did have problems with Warren County not attending, and we weren't sure if whether he was being sent to long-term treatment through another county. But prior to that, the misdemeanor allegation arose in October of 2021. Additionally, Your Honor, we would just bring the court's attention to the case that Mr. Metter is before the court on, the Cumberland County charge, involved restitution. He did pay that in full. It has been paid in full. And so he did hold up that end of the responsibility on the Cumberland County case. He worked with his officer for a while until these other problems in Barron County arose. Your Honor, he's pled guilty to those. He's tried to make amends. He has restitution that he'll need to pay for in there. We would just ask the court, in lieu of revocation, to allow him to attend a long-term treatment program, or in the alternative, to run his time concurrently with the Barron County time, so that he doesn't have additional time to do, so that he can get out and make his responsibilities on that case, Your Honor. The case also, Your Honor, the case that Mr. Metter is before the court on, should that occur today, is a misdemeanor charge. The allegation was that there was restitution in the amount less than $1,000. Of course, at the time it was a felony charge and Mr. Metter pled to the felony charge. But if the same conduct occurred today, it would be a misdemeanor. And again, he has made his restitution payments. So we are just asking the court to not revoke him, and to send him to long-term treatment, or in the alternative, to have this run concurrently with the Barron County case.
I just asked the revocation be entered while he was on probation. He committed another misdemeanor, theft by deception. Nobody forced him to do that. So I'm just asking that he be
What
revoked.
about the felonies? Did they predate the plea in this case?
I don't know. Mr. Bray didn't know. I don't know if he did or not. Unless he knows now.
Your Honor, 3 of these felony cases were reported on May the 17th of 2021. I think that was.
Do they predate the plea in this case is what I'm asking.
The 19 CR case? No.
So after he pled guilty, in this case here, he's had 4 felonies.
No, sir.
Your Honor, I think that was an ongoing investigation, so it's very possible that even though he was charged after he entered this plea, the actual conduct occurred before.
Well, somebody's got to tell me. Somebody's got to tell me. Maybe you already told me and I didn't catch it. Be quiet, sir. Just put your hand down and be quiet. Okay. Now, your attorney can call you as a witness. And this is not, let's make a deal here. Okay, now let's go back to probation and parole officer. When did the underlying activity on those cases where he pled guilty to in Barron County, when did that happen? Was it before or after his plea here, according to the record?
Your Honor, I'm looking at the PSI right now, and it says, looks like the first, says according to Officer Moore with Glasgow Police Department, the first contact of any kind of crime occurring was on 4/27/2020 by in the first case, the 105 case.
So that would have been after the 19 case.
Okay, how about the next one?
The next case, the 106. Looks like Tuesday, September 15th, 2020, for the 106.
Okay,
And the P14. First contact. On that. Looks like. It doesn't really say on this one, but it says. This PSI is not as clear, Your Honor. It says. The victim in this case sent a $800 payment for something that he did not receive on March the 23rd. It does not even say a year.
Your Honor, you've got two of them. The judgment in this case was entered September the 19th, October 31st of 2019. You've got at least two felonies that happened in 2020.
And the third and the fourth and final felony looks like May the 11th, 2020 was the first contact.
You have three.
you have 3, possibly 4 in a misdemeanor.
Yeah.
What do you have to say about that, Ms. Costello?
Your Honor, I would just, I would ask the court to not find, if the court is inclined to revoke. Mr. Metter does maintain, when we spoke on the phone, that those charges, the conduct arose prior to him entering this plea.
They did not, the conduct did not occur prior to him. You keep saying that. And that's the reason I asked him. He entered this plea in this 19 case, and then all this conduct happened in 20. Isn't that right, Mr. Stockton?
That's what Mr. Bray says the PSI said. They should have been the alternate.
Why do you keep saying that, Ms. Costello?
Your Honor, because that is what Mr. Metter maintains to me.
Well, that's not what the documents say.
I understand, Your Honor. We would still ask the court to, if the court is inclined to revoke based on that, to let it run concurrently with the sentence that he served in Barron County, given that the underlying charge here would be a misdemeanor if committed today.
What's he running over in Barron County?
Believe it is a 5-year sentence. Is that correct, Mr. Bray?
It is 5 years. All four felonies are concurrent. 5 years plus restitution in each case.
Do you have any objection to running this case with that one, Mr. Stockton?
It's contrary to the statute, but I'm not going to object.
Okay, if it's contrary to the statute, I won't do it. Can't do it. So.
You know, he can always, if he does have a legitimate rehab opportunity and he has paid restitution in all these cases, he can still file a motion for shock in this case if he's revoked.
He was originally shocked out onto this case after restitution was paid in full.
Oh, okay. So he doesn't have shock available.
I need clarification of what date you used for it.
Then October 31st.
The stamp date or the date the judge?
When does his time on this one run?
Okay, so is that September 18th?
You asked me, Your Honor.
No, I'm not asking you. Yeah, I'm asking probation parole. Yeah, excuse me.
He did, he was deferred. He met the parole board and was denied parole on 5/12, so May the 12th of 22. He was deferred 15 months until August the 1st of 2023. So he had a 15-month deferment by the parole board on May the 12th.
On which charge?
I believe all of them, because they were all they all were sentenced at the same time.
Well, I'm just going to take this under advisement. Then he's going to have to serve. How long is he going to have to serve till when?
It says he will not meet the parole board again until August the 1st of 2023. So about 11 months.
What do you think about that, Mr. Stockton?
I think nobody's built this house but Mr. Metter, brick by brick by brick by brick, by his conduct, and now the bill's coming due.
Okay,
and whether the court enforces it or not, the bill's there.
Well, I'm going to enforce it then. I'm going to revoke.
May I?
Thank you very much.
May I speak, Judge?
That concludes the matter.
So can I be called to the stand to ask the question or two to Mr. Bray and to Mr. Stockton?
No.
Why is that, sir?
Because the hearing is over.
I mean, because I didn't get a chance to speak, but these charges that they're saying that the felony charges, sir, they were committed the same time as the Cumberland County case. They didn't get, because I was paying my restitution on them to Berrien County with the Detective Mike Houchins, had them all fixed together for me to take care of them. And I was still incarcerated when I got out. He told me when I got out that they were going to charge me with it. And it took all that time for them to get me charged and get my stuff done on it, sir.
What, Mr. Stock, he's already been shocked on this Cumberland County case. Is that what you said, Ms. Costello? So he's
Yes.
not eligible for shock again.
He's on shock.
Well, you put together a case, Ms. Costello, that is documented with what your client says. And if I'm incorrect on this, I can set this aside, and I will do it if we are incorrect.
And I agree with you, Your Honor. If we've got the wrong dates, I agree with you. But I will
Sir,
go by the
So,
KSI.
Mr. Metter, you work with your attorney. See
I've
if
got
the
a couple-
date- if the dates are incorrect, I will set this order aside, okay?
Okay. And
I'll reach out to the detective on the case and see if he can't shed some light on that.
Okay, thank y'all very much.
I've got a couple other questions too, sir.
Well, you can ask her, okay?
I mean, it's not going to do any
You
good
can
to
ask
ask them.
her,
that.
we're finished, okay? You can ask her.
I mean, I can't never talk to her because they never answer the phone.
Okay, she will call.
I mean,
you.
I've got, so in other words,
We're finished. Okay, you call him and talk to him and satisfy his questions, Ms. Costello, okay?
Yes, Your Honor.
Thank you very much.
fuck y'all.
Let's go to, okay, what'd you say? You're held in, hey, sir, wait just a second there. He's held in contempt for 6 months. Put those headphones back on him. Put those headphones back on him.
Your Honor,
Yes.
you're not through with him?
No, I just sentenced him to 6 months for what he said.
Okay.
He's telling me for 6 months for contempt.
All right. Randy, you've been sentenced for 6 months for contempt for what you just did. Now, are you going to?
Okay, thank you very much.
You're
Thank you
welcome,
very
Your Honor.
much. Okay, let's go to Derek. Okay, we'll go to Joseph Arms. For sentencing. Commonwealth versus Joseph Arms, 20 CR 06660068. Are you Joseph Arms?
Yes, sir.
Okay, we're here for sentencing today. Have you seen the pre-sentence investigation report done by probation and parole?
Yes.
Okay, is it substantially correct?
We have no issue, Your Honor.
Okay. Counselor, is there any reason why this gentleman should not be sentenced?
I know of none, Your Honor.
Upon a plea of guilty to burglary, 2nd degree, 4 counts, the defendant shall receive a sentence of 8 years to run concurrently for a total of 8 years. 8 years on each charge to run concurrently for 8 years. Upon a plea of guilty of theft and lawful take over 504 counts, the defendant shall receive 5 years on each charge to run concurrently for 5 years. The 2 sentences to run concurrently for a total of 8 years. Come up with the probation. What's the court cost in this case?
$215.
$215, and that can be paid upon his release, 30 days upon his release at $40 a month. The $650 is to forfeit any interest in or pay $650 on the Ford pickup. Serial numbers on here. So I don't know whether he wants to forfeit his interest in that or make a payment. Which one you want to do, sir?
Well, if I get out, I just go and pay it off.
You're not going to get out for a while, though.
Well,
Well,
and
I
that was
understand.
my next statement is we'd ask for probation, although the Commonwealth's opposing it, but I understand that.
Yeah, but it's not going to be probated because that would diminish crime. So you can decide I guess at some juncture, you'll need to tell your lawyer and you can make an election on whether you want somebody to pick the car up and sell it for you, pay it off, or whether you want to just let it keep running.
I'll talk to her.
Okay, that'll be fine. Thank y'all very much.
Probably Mr. Cross needs to let me know in 30 days, so I'm informed the sheriff.
We will. We will.
Athena Brown. Commonwealth versus Athena Brown. Are you Athena Brown? Are you Athena Brown?
Yes, sir.
You born in 1982?
Yes,
Last four digits of social security number 4614.
yes.
Okay, you're here on a probation revocation. You're represented by Ms. Costello. What do you have to say, Mr. Stockton?
Your Honor, she has a 3-year sentence. She was being supervised in Indiana on receiving stolen property. Indiana reported 6 positive meth tests and I think over 20 unexcused misses, I think, as far as meeting with them. My understanding is she's going to stipulate.
Is that correct, Ms. Costello?
Yes, I spoke to Ms. Brown. She does wish to stipulate. She would ask the court to consider sending her to long-term treatment. She does admit that she has an addiction issue. She's not received treatment for it.
Well, she will receive treatment when she is admitted to corrections. They'll take her up for an assessment. Okay, thank you very much. Charles Brown. Commonwealth of Kentucky versus Charles Brown, 21 CR 0089 and 22 CR 0034. There are a lot of things up on the docket here today, it appears. You are Mr. Brown, is that correct?
Yes.
You were born in 1980.
Yes.
Last four digits, social security number 8162.
Yes.
Okay, Mr. Stockton, you have their pretrial conference includes motion for bill of particular for release of records to determine competency and on both these charges. Have you reached any agreement on discovery on this issue?
I thought we had supplied everything. If there's a bill of particulars, was that filed by Mr. Vaughn or by you, Ms. Costello?
No, I filed that back in June. I believe you guys have already complied with everything.
Okay.
I think it was just carried over because we had continued the case from last month since I had COVID.
Your Honor, I think there needs to be a hearing set for the court to interview the child witnesses for competency, but we probably need to wait till next month to set that when Miss McCauley's here for the co-defendant, so everybody can get the same date. Other than that, I think once we get that done, we'll be ready to set it for trial.
There's a co-defendant here?
Yeah, Christie Brown and Don McCauley.
Oh, she's
Mr.
coming up
Shively.
next. She's coming up next. Okay. And who's the attorney there?
Miss McCauley.
Don McCauley.
Yeah. Okay, so that's gonna be set on the 22nd.
If you want to do it that day.
Yeah.
Okay.
So we'll have the children here that day.
Okay, you put them in a protected area.
Can we take it up in the afternoon after school, Your Honor? Or do you want to do it in the day? When's the fall break here? Or we
Well,
could do it
They get out of school at
2:30 or something.
2:30. Let's have them taken from school directly down here. So it'll be 2:30, between 2:30 and 3 o'clock. Set is 2:30 and then we'll get them down here as soon as we can, okay? And then the provisions will be need to be made for the protection of them and observation and that sort of thing. Y'all can do an agreed order on that. And bill of particulars has already been satisfied. Release of records, what's that?
There were medical records. I don't know.
Has that been taken care of?
I didn't file the motion for a release of records. Did your office file that? I just filed the bill of particulars.
Do what? Commonwealth Attorney's Office filed it. So.
Let me get it, Your Honor. I thought we already had them.
July 5th is when they were filed.
Smack this in it.
Well, I'll just take that under advisement, and if you, I'm sure Mr. Costello will do an agreed order on it.
I thought it'd already been done. I might be wrong.
Okay. Okay, well, we'll see you this September the 22nd.
I can know
Okay.
that. See if we've got it.
Okay, Christie Brown's next. Christie Brown and are you Christie Brown? Born in
Yes.
1989, last four digits, social security number 0413.
Yes.
Ms. Brown, your attorney could not be here today. And so we've set this for September the 22nd, along with Mr. Charles Brown to have a hearing concerning, I'm going to interview the children involved on that day as far as to their competency. Okay. And your law, that way your lawyer will be present and Mr. Brown's lawyer will be present. How long have these two folks been in jail?
Quite a while, because Mr. Vaughn was in the case and then he got out of the case, and then Miss McCauley had to be conflict counsel. But as soon as you interview the children, if you want to set a trial date, Your Honor, we'll get ready. This is a serious case. Yeah.
Okay, well, what we'll do is both of you still in the room there. As soon as we do these interviews with these children, we'll set a trial right away, so you'll know some resolution one way or the other, and won't sit there in doubt, okay?
Okay.
Okay, thank you very much. Benjamin Birchfield. You know, hey, have your associate have a trial calendar that day on the 22nd, so we can set a trial date, okay?
We'll inform her of that.
Okay,
That's all I have, Your Honor.
okay, have a great day. Benjamin Birchfield for sentence. Are you Benjamin Birchfield?
Yes, sir.
You're here today for sentencing, you understand that?
Yes, sir.
You had to look at a chance to look at the pre-sentence investigation report done by probation and parole. Okay.
Your Honor, I apologize. My computer just went completely, it just shut down and said it encountered a problem and we'll restart it for you, is what it told me. So it's in the process of restarting. So I came out here to not slow anything down.
Okay, Mr. Birchfield, have you had an opportunity to review it? Did you say is it substantially correct?
Yes, sir.
Okay, is there any reason why you should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to trafficking and controlled substance first degree, the defendant shall receive a fine of $750 and receive a sentence of 5 years, serve 60 days, probate the balance for 5 years. On plea of guilty to operate a motor vehicle with alcohol content or under the influence, he shall pay a fine of $200 for plus court costs. Now, what is the amount?
Total amount $1,625.
Does that include the tow bill? Okay, $1,625 fines and costs plus $350 tow bill and storage bill at the Cumberland County Sheriff's Department in lieu of forfeiture of the vehicle. So you'll have to make that decision. Mr. Stockton, you want him to make that decision within 30 days also about whether to pay the $350 or forfeit.
Yes, Your Honor. Since there's going to be a
Okay,
changeover.
now, he's
we need
going
some
to be
resolution.
serving, has he already got his 60 days in?
Yes, he's at 76 days today, Your Honor.
Okay, now, is that 76 days to count, Mr. Stockton? Is that correct?
Yeah, that's correct. I have no problem.
Okay, so
What?
total amount with the fines was what again? $1,625. I'll allow you to pay that at $50 a month, starting 30 days from today. Okay, and of course you realize when you enter this plea that operating under a motor vehicle can be enhanced. Do you understand that?
Yes, sir.
Okay, in other words, you get another one, it'll be more serious. You understand that before I sign the final judgment? And also on the traffic and controlled substance, that's a felony. If you get another felony, it could be used against you to enhance sentence net. You understand that also?
Yes, sir.
Okay, well, I'll go ahead and sign the orders. When do you, probation pro, when do you want this gentleman to come see you? Excuse me.
They're gonna be digging them.
Yeah,
You think, so he gets released, he can compare to the Columbia office or.
okay, as soon as you, I'm gonna sign a form of release you today. You go over to the Columbia probation pro officer as soon as you get released today, okay? Sign up with him. Okay, and make all your payments now, okay?
Okay. Thank you.
Okay, okay, see you later. Denzel Burton. Commonwealth versus Denzel Burton, 22 CR 0058. Are you Denzel Burton?
Yes, sir.
You born in 1971?
Yes,
Last four digits of your social security, 1609.
yes.
Okay, we're here for a pretrial conference. What do you have to say, Mr. Stockton?
This is one of the co-defendants. I'm waiting on DPA on the conflict council. I don't know
Yes, Your
who's
Honor,
going,
Mr. Denzel Burton and Mr. William Burton. Because it's been in the works for so long, I'm hopeful that on 9/16, we will have an attorney. I'm actually hoping well before that.
Okay, we'll set up a pretrial conference for a negotiation day, rather, for the 16th of September, and the next court date.
I can't remember exactly. I think
22nd.
group.
Okay, they're gonna appoint you a new attorney, Mr. Burton, so there won't be, if there's conflict between all of you that are charged, you can have your own attorney. That attorney will be the seat. You know, we'll have a negotiation day on the 16th of September. Your next court day will be on the 22nd. Maybe get a resolution, okay? Denzel Burton.
That's
Excuse me, William Burton. Pardon me. Mr. Burton, you just heard me tell Denzel that we're gonna get each one of you your own attorneys.
Yes, sir.
And they're gonna come and meet with you, and they're gonna have a negotiation day on the 16th of September, and your next court date will be on the 22nd. And maybe this will illuminate it for you a little bit, so you can talk to your own attorney. And we'll have an opportunity to do negotiations on the 16th, and then maybe reach some resolution on the 22nd, okay?
Okay, I've been accepted into a long-term treatment. Is there any way we can get a bond? Because we still haven't had a bond motion at all.
Okay, well, I'll tell you, you discussed it. Will you call him today?
Yes.
Tomorrow?
I can probably call today.
Okay, your attorney's gonna call and talk to you privately about that, and if you give her that information, I'll be glad to sign an agreed order if it's okay with the Commonwealth as far as a treatment till we get this resolved, okay?
Oh, okay, I've been accepted into Victory Lane and Bowling Green.
Okay, well, then you tell her that.
Yeah.
And then she'll tell the Commonwealth, and I'll sign an agreed order if it's, but if you do go to a treatment, you know, you'll be under the same restrictions of not leaving as you are where you're at now, okay?
Yes, sir.
Okay, thank you.
Thank you.
Christopher Cape. Christopher Cape.
Sir.
Commonwealth versus Christopher Cape. 22 CR 0064. Are you Christopher Cape?
Yes, sir.
Okay, were you born in 1984?
Yes, sir.
What are the last four digits of your social security number?
5119.
Okay, we're here today on a pretrial conference. What's the Commonwealth have to say?
we have a felony plea, I believe, Your Honor.
Yes, Your Honor. I also have a waiver of dual representation for Mr. Cape as well.
Okay, a motion has been tendered that says you wish to enter guilty plea. Well, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is your plea voluntarily given?
Yes, sir.
Okay. State your full name, year of birth, and last four digits of social security. No, again, full name, just your full name.
Christopher Cape.
Okay, you same person named in the indictment, number 22 CR 0064. Is your
Yes.
judgment impaired today in any way?
No, sir.
Will you discuss these charges with your attorney and you're satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you?
Yes, sir.
Do you believe you're fully informed about the case? You realize that you do not have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you are aware of your rights. You have the right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses to favor, right to appeal this matter to higher court if you lose, and require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. I'm going to consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept it. Prior to accepting it, I'll do the pre-sentence investigation report by probation parole. If I do not accept it, I'll allow you to withdraw the plea. What's the Commonwealth's recommendation?
Your Honor, Mr. Cape will plead guilty to possession of a controlled substance first degree and fleeing and evading police in first degree, and to complicity to tampering with physical evidence. He'll receive 3 years on each charge. They'll run concurrently for a total of 3 years. He'll also plead guilty to DUI, be a $200 fine plus costs. This sentence, the 3-year sentence, is to run consecutively with Russell Circuit Court case number 17 CR 142, 18 CR 128, and run concurrently with Russell Circuit case 22 CR 69. He'll pay court costs at the discretion of the court. All evidence in this case will be destroyed.
Now, Mr. Cape, when you entered this plea, you were informed, I believe, that another DUI could be enhanced if you get one after this, because this plea. Is that correct?
Yes, sir.
And also that these future felony pleas could be enhanced to get other felony pleas. Do you understand that? Is this what you agreed to?
Yes, sir.
Are you pleading guilty because you are guilty of the acts, charged, and indictments as amended?
Yes, sir.
Yeah, well, I'll accept the plea. Now, is he a state prisoner yet?
Yes, Your Honor.
He's a state prisoner, so I'm going to waive the pre-sentence investigation report. Go ahead and enter the judgment in this case so they can start running on those things. Okay? Thank you very much.
Thank you.
Charles Dyer.
Good morning, Your Honor.
Morning. I'm up first, Charles Dyer, 19 CR 0082. Are you Charles Dyer?
Yes, sir.
Born in 1973.
Sir.
Last 4 digits, social security number 5164. This is 19 CR 0082.
Yes, that's correct.
This is a probation revocation. What do you have, Mr. Stockton?
Your Honor, Mr. Dyer has a 3-year sentence on possession. He was terminated from drug court. He was supposed to be on suspended status for COVID, but he was arrested for DUI and other charges down in Pickett County, Tennessee. He had no permission to leave the state or the county, so he was terminated from drug court. My understanding is going to stipulate.
Your Honor, yes, I spoke to Mr. Dyer. He does wish to stipulate to being terminated from drug court. He would ask the court for one more chance on probation and to attend long-term treatment.
I can't do that because there was a DUI involved. So I will revoke probation, and Mr. Dyer, hopefully we can get some treatment when he gets up there in a category, practice on. Okay, thank you, sir. Dylan Gilbert for Raymond. Dylan Gilbert. There is an affidavit seeking I'm going to appoint a public advocate here. And I'm going to reserve whether or not we charge anything for it. You have the right to remain silent. You are Dylan Gilbert, and you were born in 1999. Is that right, Mr. Gilbert?
Yes.
Last four digits, social security number 2080.
Yes.
Okay, the grand jury of Cumberland County is returning indictment, charging in possession of controlled substance first degree, operating a motor vehicle under the influence, possession of drug paraphernalia, operating a motor vehicle without ignition interlock device, failure to notify address change department of transportation, obstructed windshield, no registration plates, expired plates, and failure to use a seatbelt. Counsel, do you acknowledge the identity of your client, receive indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
We'll have a negotiation day on the 16th. Next court date is on September 22nd.
Your Honor, I was contacted by a treatment facility on Mr. Gilbert's behalf, Spark in Russell Springs. If I were to provide a bed letter to Mr. Shofton and yourself, would the court consider allowing him to go to that treatment as a condition of bond?
Well, you present whatever you want to the Commonwealth, and if y'all reach an agreement on it, you can present it to me. These operating motor vehicles under the influence without any kind of insurance or anything else being out there would be not warm my heart. So I think that we're having a pre-trial conference pretty quickly, if you understand what I'm saying.
I understand, Your Honor.
Okay, thank you very much. Richard Hawkins. Richard Hawkins. Mr. Hawkins, I have reviewed your affidavit. I'm going to appoint you a public advocate. Ms. Costello is here. You're here for the purpose of arraignment. You have the right to remain silent. The grand jury of Cumberland County is returning indictment charging you with possession of controlled substance of first degree, driving on suspended operator's license, failure to maintain insurance on the motor vehicle, and failure to signal. Mr. Bailiff. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll have a negotiation day on the 16th. And the next court date will be on the 22nd. The 16th will be at 1 p.m. And the 22nd will be 9 a.m. Now, there was an operating motor vehicle charge on me. What is this gentleman's bond? Pre-trial, are you there?
Yes, it's 10,000 cash. He at one point in time had an out-of-state address, and he does have an out-of-state history.
Okay. What kind of history does he have out of state?
I can't pull it. I don't have an NCIC machine here, but I know he's had charges possibly pending in Illinois right now.
No, I don't have any pending in Illinois. That were all.
Do what?
Sheriff's office went to Illinois to pick him up. So I guess he's going to Illinois.
Yeah, we had the sheriff's office went to Illinois to pick him up, so it was an NCIC's reason. So we'll have to have, if you want a bond review, there'll have to be a motion filed, okay? Okay, thank you very much.
Mr. Hawkins, they have my card there at the jail with my numbers on it, but I'll be there to see you.
All right.
Okay, thank you. Lance Humphrey. You want to go back there and see if your computer's working again?
I think it may be back up. I'll just need a couple of logged into Zoom, Your Honor.
Commonwealth of Kentucky versus Lance Humphrey, 21 CR 0018, 22 CR 00057. Are you Lance Humphrey?
Yes, sir.
Born in 1996.
Yes, sir.
Last four digits, social security number 5319.
Yes, sir.
Okay, your attorney is here in the courtroom, but she had to step out to make sure she gets back on computer. So wait just a second.
What is Charles McCoy back?
Nothing's happening in that case.
No, we're waiting on Casey. Inpatient.
Yeah.
And he is on the list to be in. No. 39 or 60 days. About that letter from KCPC. They attempt.
Okay.
to-
Now we're back on here. We're dealing with Lance Humphrey, probation application and motion for psychiatric exam. Did we get the report back on this one for psychiatric exam?
We have, Your Honor, and he was found incompetent, but the evaluator believed that he can reach competency if he's treated. And I was going to ask the court for an order for 30 days that he be placed in KCPC for treatment. Sometimes if they need more, they'll ask and we'll request an order. I think it'd be to Mr. Humphrey's benefit for treatment, but
Okay, Mr. Humphrey, we're not going to proceed with any criminal proceedings against you right now, but pursuant to the recommendation, and I'll keep the reasons private. We won't go into detail here on the record, but we're going to try to get you up there and get you some help, okay?
Okay, when y'all want to try to do that?
Well, they're
Quick
just
as
as
we
soon as we get you transported up there, okay?
Or will it be in a day or two, or?
Well, I don't really know, but they recommended and they think they can help us some. So we'll get you up there just as soon as we can, okay?
All right.
Okay, thank you very much, Mr. Humphrey. Charles McCoy. Commonwealth versus Charles McCoy.
Your Honor.
Hello.
I'm gonna say David.
Wait, don't say, hey, Charles, I'll tell you
Yeah.
when you can talk.
I got some papers saying
I can tell you when you, I'll tell you when you can talk. Don't talk till I tell you, okay? This is 22 CR.
Saying I can pay $1,000.
Charles,
You know,
Charles,
Listen to what he says first, okay?
you don't say anything till I tell you to talk. I've got to do some things before then, okay? This is 22 CR 0044, Commonwealth, Kentucky versus Charles McCoy. Mr. McCoy was born in 1965. Last four digits, social security number 1873. And what do you have, Mr. Stockton?
I believe KCPC, they was trying to do an outpatient evaluation that didn't occur. And now he's on the list to do an inpatient evaluation.
Okay, what do you have to say, Ms. Costello?
Your Honor, the outpatient they tried to do an outpatient, Mr.
I know, I read it. Yeah, I read it.
So
is there anything else to be done? Okay, Charles, can you understand what I'm saying to you?
But I was gonna say, I get out here.
No, it's not time for you to talk.
About another 3 months or a month and a half.
No, listen, Charles, you listen to me.
I can take care of all
No,
this.
Charles, you be quiet. Listen, and then you
Listen to
can
what he's
answer
saying
what I'm
first,
telling you, okay? You got some papers that said that they would do an outpatient evaluation on you, like we're doing now, and they would do an evaluation on you, but you said you wouldn't do that. So you're gonna have to wait.
I'm gonna take care of
Wait,
my-
Charles, you wait till I tell you to stop. Okay, and so you're gonna have to wait till they take you up there unless you agree to let them to do it like this. They can do an evaluation like we're doing. It'll be, I don't know how long it'll be unless you agree to do it telephonically. Okay, now you can talk.
Okay, what is it, exactly, to go to a hospital to do now?
Okay, they're gonna do an evaluation like over the internet like this. They'll ask you some questions to evaluate to see about your mental capacity and competency. Okay, they tried to get you to do that and you wouldn't agree to that.
I
So
figured I'd take care of my guy here because I want to talk.
you're not gonna get out of here till that's done. No, listen, Charles.
She can explain that to you. He looked up on the computer.
Listen, if you will do the evaluation like we're setting you doing, then that will help you.
Okay, we'll do that then.
That
Sure, it
way-
won't take long.
The last time you refused, remember I brought you in here and you wouldn't talk to
No,
her?
let's go beyond her in the other room. I
Yeah, I said you wouldn't talk to her.
Yeah, I know.
But you have to talk to her next time. That's what he's saying. You agree to talk to her the next time?
Yeah, as long as here, not somewhere else.
Okay, I'll bring you in here to do it then.
Okay, that's good. Thank you, Charles.
I think we understood what's going on.
Okay, thank you.
Christina. I might already talk to the judge now.
Yeah, I'll tell him.
What position?
Okay, I'll tell him for you.
Yeah, he's just continue Mr. McCoy's case generally until we get him evaluated. Then we'll redocket it, okay? Christina Murphy. Are you Christina Murphy?
Yes, sir.
We're here today for a pretrial conference. Were you born in 1981?
Yes, sir.
Last four digits, social security number 3208.
Yes, sir.
Okay, what do you have here, Mr. Stockton?
I've made an offer. I don't, are we ready for a plea?
Yes, we have a plea for a diversion, Your Honor.
Your Honor, I'd ask that we do Kevin Newton, the co-defendant first, and make sure he enters his plea before we do Ms. Murphy's.
Okay, let's bring Kevin Newton up then.
Yep.
Commonwealth versus Kevin Newton, 22 CR 0052. Are you Kevin Newton?
Yeah.
Okay, were you born in 1981?
Yeah.
Last four digits, social security number 0096.
Yeah.
Okay. I understand that you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person named in indictment number 22 CR 0052?
Yeah.
Are you satisfied with the advice of your attorney? You had plenty of time to talk to her about this case.
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter at higher court if you lose, and right to require the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea of guilty today, you give up those rights. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation, I will allow you to withdraw your plea and go to trial. Have you previously been diverted in the last 5 years?
This is a felony plea.
His is a felony plea, Your
Oh, he's
Honor.
gonna do a felony, right up,
I should have
okay,
told you.
okay. I think she did say a diversion plea, but I might have, you know,
Sorry, Your Honor, that was on Miss Murphy, and then we switched direction.
yeah.
I mean, we can go to diversion.
We got one vote for diversion right there, so.
And more votes.
Yeah. Prior to accepting the prior to entering this sentence, now go over the offer again, Mr. Stockton.
Your Honor, Mr. Newton would plead guilty to trafficking first degree, first offense over 2 grams. He would receive a sentence of 10 years to serve. The Commonwealth will oppose probation. The Commonwealth's going to dismiss the PFO first offense, persistent felony offender, first offense, first degree. And the $632 would be forfeited. All evidence in this case would be destroyed. And he would pay court costs at discretion of the court.
Okay, is that what you understood it to be, sir?
Yeah.
Okay, now I'm going to order a pre-sentence investigation report read by probation and parole. And then we'll bring you back for sentencing on the 22nd of September. Realize that after entering this plea today, any future pleas you'd be subject to another PFO based on this. You understand that?
Yeah.
Okay, well, I will, hold the signature up there for Ms. Costello. I'll accept the agreement and do the order PSI and see you here on the 22nd. Okay, thank you very much. Now we go back up to Miss Christina Murphy, right? Back up.
And I will be including a waiver of dual representation with both of their pleas, Your Honor. That's been signed.
Okay, that's fine. Both of you waive dual representation. You waive dual representation. Okay. Now we had a pretrial diversion going on her, correct? What are you gonna do on that?
Yes, Your Honor.
Mr. Stockton, she's previously identified herself as being having been born in 1981 with Social Security number 3208, this case number 22CR0051. What was the recommendation there again, Mr. Stockton?
It was in trafficking and controlled substance over 2 grams. She received 5 years pretrial diverted. Under 2 grams. I'm sorry.
You can't do that. I don't think you can under.
No, it's under 2. I misspoke. It's correct on the paperwork. 5 years pretrial diverted for 5 years, pay court cost discretion of the court, obtain and maintain gainful employment, all evidence be destroyed. $200 seized from her would be forfeited, and she'd pay court costs at discretion of the court.
Yeah. That's what you understood your agreement to be, ma'am?
Yes, sir.
Okay. You know, you have certain rights in the Kentucky United States Constitution. I'm gonna go over them again with you. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial with jury, right to be represented by counsel at your pre-trial, right to complain and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witness, and have process if you compel their attendance. You have the right to appeal this matter to higher court if you lose, and right to require a Commonwealth proving on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to do that. This is a diversion, however, so I'm going to have to ask you a couple of brief questions. Have you previously been diverted?
No, sir.
Okay, in the last
Where'd Clay go? Did he go home?
5 years. Do you have any felonies in the last 10 years?
Sir.
Okay, well, I'll accept the pretrial diversion. And what's the court cost in this case?
$250.
$250. You need some time to pay that?
Yes, sir.
Okay, was there any other charge, any other money amounts in the agreement, Mr. Stockton?
No, Your Honor. Both
I'll
were
let you pay that at $30 a month, starting 30 days after your release, okay?
Okay, thank you, sir.
Will she be released today? We'll
Yes,
get you
Your
an order to release you today, and 30 days today, your first payment will be due.
Thank you.
And then when do you want to meet with probation pro?
Yeah, Friday at 11 a.m.
Okay, Friday at 11 a.m. you go to the probation and parole office in Columbia to set your thing up.
Sure.
Okay?
Yes, sir. Thank you.
Okay, thank you very much.
Christina, make sure you get probation and parole's number before you leave the jail, okay? That way you have it.
I'll get all that info. Thank you.
April Nethery. April Nethery. Commonwealth versus April Nethery, 22 CR 0066 and 21 CR 0039. Are you April Nethery?
Yes, sir.
Born in 1981.
Yes, sir.
And last 4 digits of social security number 5139.
Yes, sir.
Okay, Mr. Stockton, what do you have here?
All right, Ms. Costello wanted one more pretrial, Your Honor.
Yes, Your Honor. She's a state inmate, so if we could have one more settlement conference, I think we'll be able to resolve this case.
Okay, let's have a settlement conference
Hey, Lanny, you want-
on the 16th. Next court date be on the 22nd, okay?
Thank you, Your Honor.
Christopher Christopher Toole. Is that how you say your last name, sir? Toole?
Tool, yes.
Yeah, Commonwealth versus Christopher Toole, 21 CR 0083. Are you Christopher Toole?
Yes,
Born in
sir.
1978, last 4 digits of your social security number 5822. Is that correct?
Yes, sir.
Okay, Mr. Judd, what do we have here? Turn the microphone on. Turn the microphone on.
Thank you, Judge.
Yeah.
Am I on okay now?
You're on all right. We hear you loud and clear.
The Commonwealth agrees to dismiss possession of drug paraphernalia and also operating a motor vehicle with expired operator's license, possession of marijuana, possession.
You got a
of
plea
alcohol.
agreement? Are you telling me you got a plea agreement?
Yes, we do.
Okay, let me start. A motion's
Okay.
been tendered. Is this a pretrial diversion or a felony plea?
Felony plea, Your Honor.
Okay.
Yeah, it's fine.
Okay, a motion's been made, sir, that
See if
says you
Bonnie's
wish to
is-
enter a plea today. Is that
I'm just
correct?
cutting out. Well, see
Is
if
that
this is
correct?
now. You can't hear what he's saying.
Mr. Toole?
Yes.
Okay. You've agreed to do a felony plea. Is that correct? Are you currently under the influence of drugs or alcohol? We got a problem
No.
here. Okay. Is this plea freely and voluntarily given? Are you doing this freely and voluntarily?
Yes.
Okay.
Sorry, we're having a little trouble. It's like coming and going.
Oh,
Sorry about
okay,
that.
well, we'll work through it. Okay, have you had plenty of time to discuss this matter with your attorney and review the evidence in this case?
Yes.
Okay. You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution, and before I can take a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, or right to call witnesses in your favor, have process issued, compel their attendance. You have a right to appeal this matter to higher court if you lose, your right to acquire the Commonwealth, prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation. I will not decide on that for sure until I look at the pre-sentence investigation report done by probation role in the event that I do not accept the recommendation and decide to impose a harsher sentence. I will allow you to withdraw your plea. Mr. Judd, now go over the plea agreement, please.
Thank you, Your Honor. Apologize for getting ahead of myself. Possession, the Commonwealth agrees to dismiss possession of drug paraphernalia, to dismiss operating a motor vehicle with expired operator's license, also to dismiss possession of marijuana and possession of alcoholic beverage container, no expired registration plates, and equipment of vehicle not to be nuisance or menace. Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. The defendant shall receive credit for time served and will be released at final sentencing. The defendant shall pay court costs, discretion of the court. The defendant shall obtain gainful employment or do 30 hours a week community service. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with laws of Kentucky. The defendants will remain on active supervision until any and all court costs are paid in full and until further orders of the probation parole, or further request of probation parole, rather.
Is that what you agreed to, sir? Is that what you agreed to?
Yes.
Okay. Are you pleading guilty because you committed the acts charged in the indictment as amended? You gotta speak up.
Yes, sir.
Okay. Yeah, I will accept that and I order a pre-sentence investigation report done by probation parole. You understand about entering this plea, if you have any future convictions of felonies, that the sentence could be enhanced because of this plea. You understand
Yes, sir.
that? Yeah, I order a pre-sentence investigation report and have you back in front of me on September 22nd. And if everything goes right, I think according to the plea, you'll be released that day. Isn't that right?
Yes, Your Honor.
Okay, thank you very much. Joshua Vibert. Joshua Vibert. Commonwealth versus Joshua Vibert. 22 CR 0021 and 22 CR 0069. What do we have here?
Judge, we have a plea agreement, a pretrial diversion into drug court.
And what was this one we had last week, last month? Did we have this last month?
What's it?
I'm not aware.
I thought this is the one we had last month.
No.
What's the charge here?
It's got Boris. Boris is on the left. You speaking?
I'm speaking to anybody that
Judge,
can hear my voice.
I think Jacob Boris is what you're thinking about from last month. The charges are on 22 CR 21, fleeing or evading police first degree. I have a repeated fleeing or evading police first degree. I don't know if this is 2 counts or just repeated. Disorderly conduct second degree, violation of Kentucky DVO, reckless driving, improper start from parked position, no registration plates or receipts, no expired registration plates. And on 22 CR 69, tampering with prison monitoring
Yeah, that's
device
what I'm thinking about.
and escape second degree. And then based upon a plea agreement, the Commonwealth recommends that on 22 CR 21, fleeing or evading police first degree is dismissed, disorderly conduct second degree dismissed, reckless driving, improper start from park position, no registration plate receipts, no expired registration plates be dismissed. Then on a plea of guilty to fleeing or evading first degree, receive a sentence of 5 years, and on a plea of guilty on 22 CR 21, on a plea of guilty to 22 CR 21 on the violation of Kentucky DVO, receive a sentence of 12 months. The 4-year sentence and the 12-month sentence shall run concurrently for a total of 4 years. And on a plea of guilty to indictment number 22 CR 69, tampering with a prison monitoring device, the defendant shall receive a sentence of 5 years. And on a plea of guilty to escape second degree, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run concurrently for a total of 5 years. And the 5-year sentence in indictment 22 CR 21 and the 5-year sentence in indictment 22 CR 69 shall run concurrently.
I'm not gonna accept the plea. So y'all have to negotiate something else out. I mean, you just have too many violations and fleeing and evading and escaping and monitoring devices and that sort of stuff to run all these things concurrently. I'm not going to accept the plea. So I'll reschedule this for a new negotiation day on the 16th, and we'll be back in court on the 22nd. It's okay. Thank you very much.
Thank you, Your Honor.
Yeah. Jacob Voorhees. Jacob Voorhees.
Yes, Your Honor.
Okay, for sentencing,
Your Honor, I haven't received a PSI since we were here last. There was
okay, then we can't do a sentencing. then.
well, there was one done in December, so I will waive it. I'm just thinking that's the first thing you're going to ask about. And it said,
Well, I can't waive it.
well,
Filled one, they come and I filled one out. They used the one from December. Nothing had changed. That's the one they used.
there was one done in December, Your Honor. That's
Well, let me ask you, who did, if y'all, if you look,
That's a new PSI that was sent to me this month.
do what?
That is a new PSI.
Yeah,
There is one in this case.
yeah.
I can't understand her. I'm sorry.
She says this is a new pre-sentence investigation course. I've got it right here.
Well,
When are we going to be? Let me ask you something. It's not fair to him to put it off, really, because he doesn't have it. Where will we be next week?
We'll be in Albany on the 8th.
Clinton County.
It's not.
When she come up here, she asked me if anything had changed. Nothing had changed. And she went off the one in December. So everything should be the same on it. Nothing had changed.
Well, I'm willing to accept that. Are you, Mr. Stockton?
I am, Your Honor.
And I am too, Your Honor.
Have you looked at, see if there's anything any different?
I had a guy, the officer Foley's on if he doesn't, he is tired, so.
Officer Foley, is there anything different from December to this newest one that you sent me?
No, sir. He told me nothing had changed, but I
Okay,
did
well,
update all the information for this case.
Okay, that'll be fine. That'll be fine.
Your Honor, I feel obligated to advise the court and remind the court that at some point in time, Mr. Voris did obtain a DUI since then, and that's what got him in this trouble. So that has been in 2022. That's why his pretrial diversion was voided.
Well, that's what this says. Is that right, Mr. Stockton?
I agree with whatever it says, Your Honor. I don't have it in front of me right now, but I'm not going to argue with what's on the black and white. But that was the reason for the revocation, was the new DUI. I don't know if he's been convicted of it or not yet, but we had a hearing.
Go ahead, the pretrial diversion. Pretrial diversion was was voided on July 28, 2022. So I'll sentence him to 3 years. And to run concurrent with 17 CR 0029. Is that right, Megan? Megan, are you on there?
I assume you've got my PSI there. You can see it.
Well, that's what it says. It says 3 years pretrial diversion period of 5 years to run concurrent with 17 CR 0029. And we voided the pretrial diversion, so that would implement the 3 years. Okay. Thank you very much.
Thank you, Your Honor.
Yeah,
Your Honor,
yeah.
Mr. Voris would request probation. I believe what I need to do, quite frankly, is itemize his medical issues and present that at a motion for shock after 30 days, and I'll do so.
That'll be fine. Mr. Jim A. Webb. Not to be confused with Jimmy Webb, who's next. Mr. Jim A. Webb, 22 CR 0062. We're here for a pretrial conference.
Your Honor, we need one more time on this. I think there's a motion to revoke I need to file, and Ms. Costello and I need to work out a global settlement in the case.
Okay, a negotiation date from 16th of September.
Yes.
The next court date will be the 22nd. Mr. Webb, hopefully to roll all your stuff up together, okay?
Yes, sir. Appreciate you.
Thank you. Jimmy W. Webb, the other Jim Webb.
No, it's a different case.
Commonwealth versus Jimmy Webb.
I need that.
Yes,
file.
Judge.
That's just a notion of intent to seek forfeiture. What was that forfeiture of, Mr. Stockton?
That was $1,075 cash that was seized in indictment 22 CR 12.
Was that drug money or something allegedly, or what was that?
It was part of the plea. And it was part of this case where he pled guilty.
Part of the agreement that he already made. It's not any additional money.
No, it's not any additional money.
Okay. Okay. Well, I'll go ahead and sign that order then. Jimmy, now don't you get confused with that other Jim Webb up there and try to be blaming anything on him.
I ain't going to, Judge.
Well, maybe y'all ought to compare records and see who comes out on top here. And you just kind of
Thank you, Judge.
okay, thank you. Okay, now, is there anybody else in Adair County that we hadn't gotten to?
No, that's it.
Amanda Branham was picked up last night. Was that on a probation violation? Indictment warrant. Amanda Branham. Do you have Amanda Branham there?
Amanda Brown.
Branham.
Branham.
Do we have Amanda Brown? Amanda Brown.
Branham.
Branham. Yes, we do got her. You want to see her too?
Yeah, we might as well see her in a rainer.
Okay.
What's she charged?
Give us just a second to get her up here.
Okay. Just bring it back. Is Mr. Cross still here? Did he leave? See if Mr. Cross left the building. Was that Mr. Stockton? There was a motion for briefing on Jonathan Nethery or something like that.
Yes, Your Honor.
The problem was there was additional information that was supposed to have been provided.
Yes, we got the medical records from the hospital and they were sent to Mr. Cross. And pursuant to the hearing, I went back and watched the tape. We were supposed, if either side wanted to take additional testimony, it had 10 days. And there wasn't any testimony taken. Now, if the court wants to hear from Dr. Flaggers, we'll call him.
I don't.
So we just need to, it's Mr. Cross's motion. I just need a briefing schedule. So.
Okay, thank you.
Yeah.
Okay, we have Commonwealth of Kentucky versus Amanda Branham. 000422 CR 0047. Are you Amanda Branham?
Yes.
Yeah, I've got your affidavit here and I'm going to appoint you a public advocate. Here. You what? No. Ms. Branham, you're here under indictment. And I'm going to read the indictment by title only. You have been charged by the Cumberland County Grand Jury with possession of controlled substance in the first degree, possession of drug paraphernalia, and operating motor vehicle while the license is revoked or suspended, and failure to maintain insurance. Do you understand those charges?
Yes.
Ms. Costello, I'm laying those on your desk there. You acknowledge the identity of your client received indictment, away formal reading, or arraignment, and pleaded not guilty.
Yes, Your Honor.
Okay. You want to set up a conference day on the 16th at 1 o'clock to negotiate, and then the 22nd. And what's this lady's bond pre-trial?
It's a 15,000 clerk approved surety.
Now, ma'am, you got somebody can sign a surety for you here in Kentucky. They don't have to put in, they just have to prove that they're worth 15,000.
My mother-in-law was supposed to have signed it this morning. I thought.
Okay. Okay, well, when she does, you'll be released and then you'll get a hold of Miss Costello there. And then you'll be here on the 16th at 1 o'clock for negotiation and then the 22nd for your next court appearance of next month. And both of them are conditions of your bond, okay? Okay, thank you very much. Adair County, we have anybody else there?
No, that's it.
Thank you for your cooperation.
Can you,
Thank you.
give her- will you give her one of my cards, Christie, so that she has that?
Yeah,
So she has all my numbers on it. Thank you.
I will. You're welcome.
That's it.
David Williams.
Oh,
All rise. Circuit Court, Judge David Williams preside.
Thank you. Everybody be seated. I guess we'd start out with the child support docket. Good afternoon, Mr. Bell. Graves versus Graves.
December the 15th.
Pennington versus Pennington.
He's paid in full, so it's over.
Over. No satisfied customer. Right?
No doubt about it.
Stevens versus Severe.
He's paying review 15th of December.
New versus new.
Katie Gladwell, formerly Katie New. I think Mr. Bell has called a motion to modify or establish child support. And we have a hearing in this case set for October the 12th. It's going to address the issue of child support because we're asking to change placement of the child. And also Mr. New has some back child support.
I read the motion last night. She had the child for a while and he was paying child support. Now he's had the child for a while and wants child support.
Well, but that's the issue. We modified the child support and he didn't start making payments until he filed his motion to modify. So he didn't pay the child support on the agreed amount that was ordered for several months. And then we went to court and then the child came to live with him. And now we have another motion for the child to go back to her.
That's pretty clear.
There's no.
Yeah.
So I just ask that you hold this in abeyance until we have that hearing.
You don't have any objection to that, do you? What do you want to do on it?
I mean, Mr. New probably would, oh, we have it, December order, you want to pass this.
When you say he's in arrears.
Yes,
for
Judge.
that?
We went back and there's orders in the file from back last May where we had an agreed order where we were modifying child support because it had been put off. I think there was originally a motion to modify child support October.
Let's just get back. I don't care what days they were done here or there. Are you saying he's in arrears on a previous order? Is that
Yes.
what you're saying? But it's really outside of your province to have to worry about that. So what I would do is, if you got a motion coming on
Judge, we just set a hearing date. We already had a motion last
for the
month.
commissioner, you mean?
Yes.
Yeah.
So I just ask that you hold that in abeyance until we have a ruling on that hearing.
Well, I tell you, will that affect the back child support?
It could potentially because we may be able to agree on those amounts.
What I would like for you to do is just submit, I'm going to pass over it for this month, but I'd like you to submit proof to the county attorney. There should be a set off against what they say that they've calculated.
All right.
I think that's fair to both sides, okay?
Thank you.
Okay. Helen versus Bo. Helen versus Bo. Is that one of your cases?
I think they need to pay now, so we can do this one. Yeah, it's finished.
He came in and paid off, so this is finished off though.
Okay. Anderson versus Walker.
America.
Rebecca Sue Bird versus Billy Farley.
We're just gonna continue generally, probably read Docket, I think he was invited.
Warren versus Brown.
December the 15th.
Stites versus Cowgill.
December the 15th.
Cooper versus Cooper.
Do we want to try to take a
Yeah, that
chance?
didn't come up.
It says motion to intervene. What is that?
That's a motion to intervene in the civil action to request child support.
Okay, explain this to me. I don't.
Evidently, divorce action pending in the circuit court. We filed a motion to intervene.
So you just want the county attorney's office to intervene in that.
Since they're
So
both
it's
here.
not prejudice to either party then. So they just come in. Who has the child support order now?
There is not one in place. You have custody.
You have the, come on up. just
There's
a
no
little.
legal custody order. in
Well,
place.
you just move over to, let her over on this side and y'all get in the middle there, okay? Now you're Mr. Cooper. Okay, Mr. Cooper, you have the children now and there's a contested matter,
Yeah, like I just got this on the
just
20th.
a contested matter. This is not a contested matter. This is just the county attorney's office intervening into another actions going on between the two of you, right?
I'm not sure what action that is.
Well, Lindsay said there was an action.
There's a separation agreement.
We reconciled after that in 2018 and we had reconciled since that and then split up again.
Are you have an attorney? You have an
I do
attorney?
not.
Well, it sounds like to me both of you need to get an attorney,
Yes.
you know, because it appears that there's going to be some question as to the impact of the previous separation agreement, whether it was voided, whether people went back together, whatever.
Yeah.
And that's the reason that you want to intervene in that, right? Instead of trying to try it all yourself. Okay, I'll sign this. Now, let's just so we know what we're intervening into. I don't know what the case number on the other case is, but I advise both of you, you know, maybe to get an attorney and take a look at that case number and where you got it, things like that. Was that a divorce action?
It was a legal separation.
Well, but y'all were married.
Yeah, we're
You were
still
married, so it wasn't it wasn't a paternity action. or
No.
anything. Okay, well, I won't take any other action on it. I'll just wait for y'all to decide how you're going to advance it. Okay? Thank you very much. Tasha Cash versus Seth Roberts.
December the 15th, early, so that's all we have.
Okay, thank you. Okay, let's go to the civil docket. Riddle versus Collins.
Good afternoon, Joe.
Oh. Let me have that file. Okay, the only thing I have is an e-file copy of, says come to respondent Kelly Collins through counsel and provides the following notice that her motion to amend visitation should be brought before the court on Tuesday, August 30th at 1:15 for a hearing to discuss the issues and obtain an evidentiary hearing date. What's the motion?
Judge, last August, I filed a motion on behalf of Ms. Collins to modify the time sharing. The court had about a year prior had rendered the decision, would split the time of the child between Ms. Riddle. She got 50%, Ms. Collins got 25%, and the father got 25% of the time. Not long after the court delivered that order, the father had probation or parole, I believe it was probation, had that revoked, plus he picked up new charges. It looks like he's going to be incarcerated for the foreseeable future, but that leaves a large chunk of time.
I thought we've already heard this.
I don't think we've ever presented a hearing to the court. We've been in front of you on before. At one point, we agreed to go to mediation. We did try to mediate. We were unable to reach any sort of permanent agreement. So we have no new orders from the court since that 2020 order. Which divided the time between all three parties. And of course, one of the parties is no longer able to exercise.
You want to come over here?
And so that's what we're doing. We're asking the court basically to give Ms.
You want
Collins.
a hearing is what you're doing.
Yes, sir. Yes, sir.
Go ahead.
Judge, in response to that, of course, the original order had the provision that if there was an emergency or some foreseeable issue that happened where one parent couldn't exercise their time, it automatically went to Ms. Rose. Obviously, Mr. Riddle was picked up, placed in custody, but it's my understanding he has a parole hearing that's coming up here very shortly. So this issue may become very moot because if he's released on parole, then obviously he would just resume his visitation time with the child.
Be shocked if he gets parole. You know, I mean, I don't know, but you can't tell what the parole board does, but I mean, I'm not shocked on anything in particular to him, just shocked on what the parole board's doing. They're not, you know, they're holding people over that have nothing charges now, you know. I mean, I don't even know whether they're paroling anybody much or not. But who knows? It's been their wisdom. I just feel like that this case has been resolved. I don't know. I guess I can review. I thought we already decided this.
I'm not sure if the court means back in 2020 with that order or since then.
Or 2020.
We would argue not. We would think that 25% of the time unaccounted for is a significant issue. Another way to look at it is it appears as though the court said it wants the child to have at least 50% of the time with the biological parent. That's what was provided for in that order. And now, due to circumstances with his reincarceration, he's getting 25% of the time with the biological parent. So that.
Well, the problem you've got is you came into this case after 15 lawyers.
I understand. Yes,
and
sir.
I've heard all about this. We've had all kinds of hearings. The problem is I wanted to not to have 50% of it with that biological, from what I've heard. I don't have anything against her personally, but you know, I've heard all I need to hear. Now, if you say that there's some changed circumstances, and there always is a possibility of redemption and changes in people and all that sort of stuff. But is that what you're gonna? That her circumstances have changed since the last time we visited this?
I think in the year.
Excuse me, go ahead.
Yes, I think in the year, even since we filed, there have been new additional issues that have come up. We've got some concerns with how he's performing in school. She has certainly continued her road of improvement from when she was first in front of you. So we do think she's in a substantially better place. We do think that there's some new emergent issues. And again, we would add to that the issue of the unassigned, the 25%. And I'll make a comment on that because your order does provide that in the event of a catastrophe between either of the parents, the time would be assumed by Ms. Riddle. But the way that that's used, and I would think necessarily, that's got to be a temporary issue. Otherwise, what that would do is have the court saying preemptively ruling on the change without having heard what that change would be. So the way we see that in the order, of course, it's your order, you would know, but
Well, it
that's
was
temporary.
pretty- Let me tell you, it was pretty predictable at that time, either way, what the change was gonna be. And I'm glad that Ms. Collins has avoided that change. It appears, I hope she is on the way to heal herself and that sort of thing. Have only the best, best thoughts about that. But at that time, it was pretty evident to the court that one or the other of them had a good probability of being absent from this child's life. That's just the way it was, and this was going to do it. So, what do you have to say about whether or not what it would take to reopen this thing? I mean, the order of the court is now that that Ms. Rose assumes that the part that either one of the parents would forfeit because of an exigent circumstance. Probably that word's not in there, but
I think the court used catastrophe.
Yeah, which is.
And Judge, frankly, I think a parent going to jail would qualify.
It's catastrophic,
In a response, I have concerns over the continuing issues that have continued in Ms. Collins' life. I know that she's gotten herself off of the substance abuse issues, but we still have some instability and different things that have been going on throughout the 6 years I've been in this case. And so in this.
You get in it late because it seems like it's been going on longer than 6 years.
I got in it 2 years after it started.
So I know it's been here about as long as I have.
So that would be our position, that there's not really a circumstance to reopen this. I mean, and just to refresh the court's memory, not only had you issued a final order, it was appealed to the Court of Appeals, it was upheld, and then the Supreme Court denied to rehear it. So I think that order stands as
Judge
is.
Lawson looked at some things and he looked at it because I sent it over here for the dependency, abuse, and neglect portion of it, just to make sure that someone else took a look at it, and he brought it back, and I used those findings again, I believe.
Yes, and we had well over a 10-hour hearing on those issues, Judge. So it would just be our position that, this should not be reopened. And from my understanding and all the parties, Ms. Rose has been giving extra time to Ms. Collins.
Well, here's the thing about it is, if you feel like legally, I'm gonna find that we finalized that other situation, that order is still in place. If you feel like that you can come up with ground sufficient to alter the present custody situation, then you need to file a detailed motion like you have to file in order to show that the circumstances have changed enough that there needs to be, that we need to take a look at it. I mean, you're always entitled to do that, always entitled to do that. But I do think that the other order was a final order, and it's a firm order. And if she proves that her circumstances have changed, or on the other side, if the changes for the child have been detrimental, or there's some kind of problems that haven't been addressed, then we'll take a look at that too. I don't know. Obviously, don't know anything about the case. Nobody is around in public places anymore since the COVID stuff. So I don't see anything, hear anything. So I haven't formulated any opinion, don't know anything about it. But if you feel like you can meet the burden of a change sufficient, then file a motion in detail and you respond to it. We'll schedule it quickly, okay?
Yes, sir.
Thank y'all very
Thank
much. Yeah. Yeah, absolutely. Yeah. Wheeler versus Appleby. What is Wheeler versus Appleby? Something with show cause. Who? Who was it? Mr. Cross.
I think our attorneys are in a meeting.
Okay, well, I'll just pass this up and come back later. Y'all just take a seat back there somewhere. Kazasri versus Kazasri.
Hello, Your Honor.
Hello.
I'm Trevor Stonecipher, and I represent the plaintiff in this matter, and I believe you have before you a motion to withdraw from this matter. I also have signed by opposing counsel an agreed order of dismissal for your consideration as well, if I may.
What was this case about?
Your Honor, this was a divorce between Ebony and Justin Kazarowski, and at the start, whenever I began representing.
Have they reconciled?
No, they hadn't. Up until recently, I was told by opposing counsel that even though Ebony Kazarowski had an EPO against Justin Kazarowski, they had been communicating without even informing us of the matter. And
have they reconciled?
Yes, Your Honor.
Okay, good deal. Now, Sam, you're removed, your withdrawal, and be on your way rejoicing.
Thank you, Your Honor.
I always tell you what my first law partner told me. He said, you make a living by the cases you turn down, not by the ones you accept. Okay, thank you.
Thank you, Your Honor. May I be excused?
Yeah, absolutely. Everybody's Mid-South Capital Partners versus Cheryl Cash Young. This was a
Good evening, Your Honor. Judd Patterson from Mid-South Capital Partners. It's our motion for settlement of judgment default and order of sale.
Yeah. Okay, well, I'll take a review of you. You got the cost outlined in, I noticed.
I do, Your Honor.
Okay, well, I'll take a look at it and try to enter it today.
Thank you, Your Honor.
Roger Spivey versus estate of Leslie Thrasher, deceased.
Good afternoon, Your Honor. Beth Eric on behalf of the estate of Leslie Thrasher. This is my motion to dismiss for failure to prosecute.
Where's Mr. Hurt? He was here.
He was here.
He's here somewhere. Mr. Hurt? Trying to slide one through on you here, Mr. Hurt. You better get up here.
I honestly haven't met Mr. Hurt before, so I
We
wasn't aware
corresponded by
he was
email.
here.
Yeah, and I read the motion. I'm sure the court has as well.
He's fixing to be an important man around here. You better be nice to him.
What about that?
He's gonna be child in charge of child support, so. What's the deal here, Mr. Hurt?
Well, I lay out briefly the.
Okay, what do you have to say on the other side?
That's my position.
Go ahead, Mr. Hurt.
We sent a summons out, and this is against an estate. And so my understanding has always been an estate has a duty to receive service on it. The certified letter came back unserved. I don't.
Who did you serve it on? One of the
Administrator
administrators?
of the estate. I think it's a Mary Thrasher. She lives out of town. I don't know her. I
What do
don't
you
know
have to say
where else
about
she might
that? Have
be.
you looked at the file? Is it proof in the file that you attempted to serve it on her?
Yeah, I think it's returned unserved. in the
It
file.
was returned unserved. He made one attempt to serve her. Yes,
Okay,
that's
and you
correct.
represent the estate?
Yes.
Will you receive service for the estate today?
No, I will not.
That's what I've run into, Judge. is
What?
We entered, we reopened the estate by an agreed order with the estate, so they know it's out there.
Well, we're not going to dismiss any lawsuit like that. Just tell him who he serves it on. Let's just take a look at it.
Thank you, Judge.
And,
I'll speak with Ms. Higgins and maybe we can.
yeah,
resolve this.
maybe she'll soften up since you're a newbie here.
I'm young.
Yeah, you
and
got
help us.
cut him a little slack here. You know.
He will have to speak to Ms. Higgins about that, and I'm Ms. Eric.
Oh, I'm sorry. The notice that I got was from Ms. Higgins. That's who I've been emailing with. So I'm sorry. I just assumed that you. But I will do that. I'll correspond with her. She and I have emailed back and forth.
Well, maybe y'all could step out and call her when you leave here, you know, and see if you can get this thing moving.
I'll reach out.
What is it? It's a personal injury case? What
It
is
is, it is, Judge, and it's within the limits by the agreed order. So the estate itself has no exposure to it. So it would not take.
Well,
very much
I knew Mr. Thrasher, and he was killed in a motorcycle accident.
It was this,
Yes,
this accident that is the
Is that
subject of
right?
this
Yes, sir.
personal
Okay,
injury.
well, he's a good guy. He
Yeah,
was,
it's a very good family.
yeah.
The estate has no exposure. I'll speak with Ms. Higgins and see if we can get something. Resolved.
You don't represent the insurance company, do you?
Your Honor, I don't represent the insurance company.
That's the correct answer. Nobody represents the insurance.
That's right.
company. Okay, well, see if y'all can work it out, okay, but I'll deny the motion to dismiss, and then if y'all make some arrangement for service, it doesn't take long to advance something on the docket. I know these estates need to be wound up or something like that. Okay, thank you very much.
Thank you, Your Honor.
Yeah, Taylor versus Taylor. Taylor versus Taylor.
Good afternoon, Judge.
Hello.
This is a motion for the court to enter a default judgment against Mr. Jimmy Taylor. We have attempted to serve him by way of the Secretary of State and was unsuccessful. We had.
What kind of case is this?
It's a divorce.
Yeah.
We had
I
it.
didn't see that. Okay. Where do you think Mr. Jimmy Dale Taylor is?
It is her belief that he is residing with his grandmother at 4615 Cypress Bend, Austin, Texas. We had a warning order appointed. They attempted to make contact with Mr. Taylor by
Looks like
phone.
you had a long arm too, huh?
Yes,
Is that right?
I believe so, Judge.
Good. Were the children involved?
There
Yes,
is
there are.
one
It's
minor child.
One minor child. Is he paying you child support now? Or? Is the proof in here? You took depositions? Anything?
There is a deposition of written questions of my client, should be in the file.
Okay, well, let me, let my staff while you're look at this. I mean, services, you know, see what kind of arm we've got on this person here. And we'll make, in all probability, we're here today. Take a look, make sure. I didn't know exactly what it was. It kind of slipped by me. It said motion for default judgment. I didn't see anything about a divorce or anything like that, or the service issues. So I apologize for not catching
Oh,
that.
that's
Okay,
Thank you, Judge.
okay, have a great day.
You too.
Okay, now we have, is it time for, it's not time for the 2 o'clock docket. We'll come back in 2 o'clock docket. Now, I guess we got some people that are back there meeting. Wheeler versus Appleby. Will you see if they're ready back there, Madam Bailiff?
This is that. If you want to review that.
Without the record.
Let me just come over to your office when I get done. Are you good at You're doing. Yeah, I'll just take Jen off with those little names. Okay.
What's Mr. George? Where is that case at? I have a document on here.
Maybe I'm trying to. It's a very county case that you're supposed to take on.
Okay, let's, yeah, I'm gonna take it a Adair County case up, take as much time as you want. Okay, let's go to Adair Circuit Court meeting in special session. Division 2, Alec Thomas Bryant versus Terry Lynn Bryant.
Good afternoon, Judge.
Oh, Mr. George. It says
Judge,
take notice that an order setting a matter for final hearing. And this says an order also submitted an order for a rule against Mr. Bryant. Is that correct?
Yes, Your Honor.
Did you get, who is his, I don't have the benefit of having.
He
the
doesn't
file
have
here
an
with me.
attorney. Your Honor, what this is about, you had ordered and paid certain bills, marital debts, and he refused to pay them. His ex-wife has had to spend her money to pay the bills. And we made a motion for a rule, and we tendered an order to make the rule returnable.
There's an attorney that called the office and then.
Okay, speak up.
There was an attorney that called the office and then went through this case. I don't know if she recommended.
What is the name?
Olivia was on.
We did get a contact earlier today for an attorney that wanted a Zoom link on here about this case, but I don't see anybody on there. What time was it scheduled?
1:30.
1:15, so Central Time, so, yeah, so that's long past. Well, the problem is this is, it says this matter having been submitted to the court on September 23rd, 22 on the various motions. And it says the rule returnable against the defendants hereby absolute, and he shall appear before the judge on the 30th day of August. So if I signed an order today requiring him to appear on the 30th day of August, I don't see how anybody can comply with that. Is there a typo there somewhere?
Actually, Judge, you had told me last month, make it returnable for today. But listen, that's not a problem. Why don't we just put the September date in and come back next month?
Okay, well, I'll just change, if you'll send me an order saying it was submitted on today, which would be August the 30th, and then have him to come on September 22nd, okay?
Yeah, I'll get it done. Thanks, Judge.
Okay,
Good
thank
seeing
you all
you.
very much. Yeah,
Take care.
yeah. Okay.
Just take the orders from. There's one agreed order for.
We're already.
Yeah, to be able to do that, and that's what we're gonna just kind of get the water in. And also talk to the but the supervisor is the one who's supposed to go in there and do that checklist to make sure they have it. And it's gotta be done, and if it's not being done, then to cook, again, so it falls back. Oh my. You know, so, you know, that's all we're trying to do. You know, and then, especially, so, you know, I've done that to the point to where it should be.
It's my house. It's volunteer, my house. Okay, okay, I couldn't figure it.
No. Oh, no, no, yeah.
Feedback here. And get along to basically.
All right, you can see. Okay, let's go back to on the record here. Wheeler versus Appleby, 17 CI 0038.
We've got an agreement to report to the court, I think.
Okay,
You want to cite it? Judge, parties, I think, have some making up to do between the two sides of the family. So we've got a temporary agreement that we would like to revisit on the 22nd. In the interim, Miss Wheeler will have time sharing with the children this Saturday, the 3rd, from 12 until 4, and the Saturday, the 17th, from 12 until 4, supervised by either her husband or her stepdaughter or daughter. And we'll revisit on the 22nd, hoping that good progress has been made, no disparaging or derogatory remarks be made about any party to the case.
call it a status quo.
Yes, sir. Yes, and then I think we would like mutually to ask for the court to appoint either a GAL or a friend of the court just to speak with the children. I think both parties are desirous of that. Court's amenable to that.
Who's next on the list for that? No. We'll take a look, see
Yeah,
who's
that's
next
fine,
on the list.
Judge.
We'll do an order.
We'll
today.
tender an order.
It's in an order, Blake, we'll fill it in.
Put a
okay?
blank on there.
Okay, thank y'all very much.
Thank
Judge. Do we have anything else on the civil docket? Okay, so we're going to go now to the EPO docket. Huh? Yeah. Keserowski versus Keserowski. This case where the other case was dismissed earlier. Keserowski versus Keserowski.
Oh, you're good. That's all.
Is she on?
For me.
Can you hear me, Ms. Keserowski?
Yeah, I can.
Okay. Now, earlier today, there was a civil action that was dismissed by an agreed order. Now there is a amended domestic violence order that is about, or a domestic violence order that is about to expire. And there was a hearing date set for today here. Now, I don't see Stephen here. Is Stephen on the line? Yes, are you wanting to drop this, Ms. Keserowski? Is that what you said, or you want it to
Yes.
continue in place?
Yes, I'd like to drop
Okay.
it.
Okay, and he's not present there with you, or you're not under any threat situation or anything, are you?
No,
Okay, so you're doing this for your own free volition, you not feel
Yes.
like you're under any pressure from anyone. Okay, well, I will sign the document and get you a copy of the order, okay?
I appreciate it, Mr. Williams.
Okay,
Thank
take it easy. Yeah. Good luck to you. Make sure I sign this later. Okay, but Mateo Watson versus Barry Shane Roach. Now, is Mr. Meredith still representing you?
Yeah.
Okay, now is that in the other case? It's not in this.
That's in their custody case, Your Honor.
Do what?
He hadn't been in on it.
Okay. You can come on up here and stand on this side over here. Okay,
Judge, I know this is on today about the request to renew the DBO.
yes.
And it's my understanding Ms. Watson went in and filed a violation of that over the weekend based on some messages that she had received from Mr. Roach in violation of that. And so we would ask that it be extended. And then I have copies of those for the court where
Do
he
you
is.
want to get them for me? You have copies on Mr. Rhodes.
I do not, Your Honor.
Let's make copies of these real quick.
I apologize. I didn't know if Mr. Roach would appear or not.
Okay.
I've got these two that are the ones that are stapled if she needs those. It's the same thing. They're just not stapled. She's already taken it out. Okay.
We'll get Mr. Water. Change these in. I believe, that was just a repeat.
Judge, just to put the court on the notice, we will be filing a show cause motion in the civil action too. We just couldn't get it filed with the time frame when he sent the messages. Because he's in clear violation of that order as well.
You will raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yeah.
Go ahead and establish a foundation for these things, where they came from, and that's what.
Right, if you would, are you the same individual that's named as the petitioner requesting a domestic violence order be entered against Barry Roach with this court previously?
Yes,
And you all share 2 children in common?
yes.
All right, and Is it your understanding that Mr. Roach is not supposed to contact you and
Well,
make?
it's not her understanding. Let's look at the order. Get the order there.
Per your all's previous order was Mr. Roach not to have contact with you, except that you all can communicate through a parenting app, both through your custody action and this domestic violence action.
Yes.
Okay. And was he also not to make any derogatory or non-threatening comments only to you concerning about pickups and exchanges for your children?
Yes, and if there's an emergency.
And in fact, have you received communications from Mr. Roach that are in violation of both the domestic violence order and what your understanding was of the custody order?
Yes.
Right. Has he contacted you through the parenting app and made any certain statements?
Yes.
All right. Has he also posted things on social media and contacted you in any other way?
Yes.
And what other ways has he contacted you as well?
He will call, when he calls to the girls, he'll start in then to them about me. And I can hear it. And then I'll make them hang up or he'll call right back. Or he just does it in the app. It's all in there. He'll do it in there too. It doesn't matter. Just does it constantly.
And does he also have the ability to communicate directly with both of your daughters?
Yes, my oldest has a cell phone that he provided for her, and that's what they communicate on. And sometimes I'll even let the little one call on my phone. I'll unblock him, and then she'll call, and then I'll block him back.
And have you seen some of the messages that he's also communicated with your daughter?
Yes, I have.
And do some of those messages raise concern for you?
Yes, they do.
And is it your understanding that in some of those messages that Mr. Roach sent this previous week, that he was indicating statements about what was going on in court with your child?
He did.
All right, what did he tell?
He told her that I was making him go to jail and that he wasn't going to get to be daddy anymore and that he loved them, but that I was doing this to him. And he tells them that anything that happens bad in their life, it's all my fault, that I've done it to them. And then when my daughter didn't give the response he wanted, she just said, okay, I love you too. He told her he didn't want to be daddy anymore because he fights for her all the time and she doesn't fight for him. And he couldn't believe that she was letting me do this to him.
And has someone also provided you with Facebook post wherein he's discussing your all's custody matters and issues?
Yes.
On social media? And in the parenting app, I think we've attached copies of those too. Did he also make some statements that you perceived as threatening towards yourself and your mother?
I did.
And what were those statements?
He said that he did not, he was going to be seeing my mom face to face real soon. And that I needed to keep both my eyes open at all times around, because I never knew what was coming around the corner. And that I would regret and pay for everything that I've done.
And so did you perceive that as him making threatening statements that could possibly harm you, your mother, or other
Yes.
members of your family? And would you like for the court to extend this domestic violence order out?
I would, yes.
And did you in fact come this weekend and fill out a statement to that effect, asking the court to?
I filled it out Friday, yes.
I don't have any questions of Ms. Watson.
Do you have any questions?
Yeah, I do. But I'm.
Yeah, I want to move over here.
Can I put my side?
Sure. Yeah, sure. Let me get over here. Take plenty of time. Take your
I'll
side.
hold it down a little bit.
You can take it off completely while you talk if you like.
All right, Your Honor. Some of them was, as far as to her mother, I didn't know the EPO was on her mother. And there was not nothing else physically going to harm her because she's been in the middle of it since day one. She tells me what I'm going to do with my kids. And when I was saying that, I was going to see her in court because I've got some photos and stuff of things I want to show that later on down the date. As far as her saying that I do this to her, my 5-year-old, she don't know how to use the phone. She can't call me. And I contact Mateo one time through a text, what kid's doing. And up to the last week, she responded. Nothing, no big deal. This last week I'd asked, she sent back, ain't none of your business. Contact only your kids. I can't contact my 5-year-old on the phone. And my 10-year-old Saban,
she is on the phone all the time to her buddies, so she ain't got time to talk to them. They tell me it's none of my business where my kids are at, what my kids are doing. They take them to the doctors, dentist, whatever. I never get told nothing about them. If I ask about anything, they don't have to. She don't have to do this. My daughters, I say, when I was talking about, them doing like doing, why don't y'all call me? They're afraid to, because their mom will get mad. The 5-year-old said that. Afraid because their mom will get mad and yell at them. I've heard it myself. And then the way Matea contacts me, where I've not got it recorded, is through a phone. She'll jerk it out of my daughter's hands when she hears something that she don't like, that I ask my daughter. But I think I've got every right to ask my daughter what's wrong, why she don't want to talk to me. I think that's my right as a father. When she hears that, she jerks it out of her phone, out of her hand, and starts cussing me in front of my children. She stands with them every time I talk to them on the phone. She's standing right by them, just like last night. I told my daughter, I said, Saban, if you cannot reply to my texts or when I call, and that phone shows me when she reads the texts. When she reads them and don't reply, this says something, what are you doing? How was your day? Can you call me? And she don't reply. I think any father would tell you that they'd do the same. If you cannot reply to my message or answer my calls, I'm going to take your phone away from you. So in the background, Miss Matea says, tell him do it, Saban. I'll get you another one. But a year ago when Saban was wanting one, she didn't have the money. She ain't had the money until she gets mad and tells her, and like sort of going against me. But the day Miss Watson kicked my 10-year-old daughter out on a Sunday morning, kicked her out of the house, a 10-year-old daughter, told her she had to leave. Took her to Miss Shay Watson's house. And Shay and Matea sat there, made my daughter leave, kicked her out, and I had to come and get her. Kicked her out. Judge, Your Honor, she kicked my daughter out of her house. But I'm the bad person. I don't kick my daughter out. I went and got her. Yes, it does make me mad when I try to talk to my kids. And because she thinks that everything she does is right, everything I do is wrong. I love my kids just like she loves them. She's right now looking at me and laughing, smiling. But it's the facts. I've got the messages if we need to print them off. But I don't need messages. I'm telling the truth. I mean, what parent kicks a 10-year-old out? I don't jerk a phone away when they're talking to their mom when they're with me. I'm not even in the room. But anything the kids needs, who do they call? They call me. But when I just want to know what's going on in school, what's going on with their health, I get told I don't need to know nothing. Any father would be mad. Any father, and I've never threatened saying I was going to hurt nobody. Not one sentence did I say I was going to hurt anybody. A lot of people in this room know me all my life, and I've never touched nobody. But there's one thing I do. I love my kids. And I'm having to sit here for the, 5th or 6th time, fighting to try to love my kids. And I guess it's wrong. I don't know. I don't know what rights I've got as a father. And when
that other case, we can address some of that.
Right.
Yeah, I'm talking about this with you violated the protective order by communicating with her. And do you have any particular questions you would like to ask Mr. Roach about things that he has said in these communications? And you can inquire of that, okay?
Mr. Roach, you don't deny that you were the one that actually communicated those text messages, do you?
Me sending them to her?
I mean, those messages we provided you copies with, those are the messages you sent, are they not?
Yes, it is. And can I say one thing?
Well, I'll give you a chance.
Okay.
And you're implicating that somebody's going to show up at
Okay, won't you read the portions of it particularly?
I don't know what
with particularity, so he can respond to it.
You could understand how someone could you can tell your mama she will get to see my face to face real soon. And for you, I swear, Matea, you're going to regret everything you're doing. And you can hide behind the judge.
Mm-hmm.
You can understand how someone could take that as a threat, correct?
Okay. Okay, go ahead.
It's my turn to ask the question.
Yes, sir.
And you making threats to do something about some type of alleged illegal activity, but you can also understand.
Why don't you read that portion of the text so he can respond with particularity because words matter?
You're making a threat to her about telling to Matea all the illegal shit you're doing, even the drugs you're going to pay for. You can understand how someone can interpret that as a threat. And you don't deny that you were in present court when the judge acknowledged that you were not to have that type of contact with Ms. Watson, do you? And you understand that telling your daughter that you're not going to be her daddy anymore could be taken as a threat as well. And you also understand you made those statements in the text message saying that if I don't get my time, you don't get your money as well.
Right.
That has nothing to do with you all communicating about co-parenting, does it?
It's about the kids. But if I'm not.
That's not anything about a doctor's appointment for the children, is it?
Okay.
And that's not anything about a pickup or drop off for your children, is it?
Okay.
And you understand that's what your communication was limited to, don't you?
Okay.
And you also understand you all are to communicate through a parenting app, correct? But you don't have any of these alleged text messages today that you're bringing that says that.
I don't need no, I mean,
But you understand you're here in court today to
I
provide proof,
understand, I understand.
and you didn't bring any of those today to present as proof.
No.
did you? No further questions.
Okay.
What, this particular thing, it says, read them, your mama working today, or she home, someone might come see her. What does that
Okay.
mean?
I don't know, I was gonna wait till I guess the custody, whatever. Okay, I've got pictures.
No, I'm talking about
Okay.
this statement here.
The statement is, because I was gonna go to the law in Tennessee, where I'm from, and give these pictures of bruises, welts, that my daughter come to my house and showed me.
No, I'm not. I'm
And
asking you
okay, that's what that
I'm
means.
asking you what this statement meant.
It
So
means
you're
that
saying that it meant that someone from social
Legal.
services might come. see
Yes,
you.
yes,
Okay.
sir. I've got the pictures.
I'm just asking you what it meant, because we're talking about these communications. You don't have a right to bring all that other stuff up in
Okay,
there.
I'm trying not to, but
Okay. Well, you can bring anything up you want to.
and Your Honor,
If it hurts you that bad to tell me when she has practice, you're nothing but a piece of shit. Now, does that sound like a communication that I told you not to make when you were up here on that EPO? Does that sound like that to you?
no, but,
Okay.
okay,
Well, you are that, but you continue to do what you're doing. You are going to go to counseling because you're doing nothing but mentally hurting our children. And if it means I'm going to show the pictures of you and your secret to let everybody know who really are, does that sound like a threat?
I guess, I mean,
Yeah, I guess it does too.
and can I say, one thing?
Yeah, you
I
can
asked her
say
to
anything you
extend,
want to, but
I asked her to extend the EPO. In a text message, I said, I believe we need to extend the EPO. I did.
now what are these things? Are these exhibits to things that were said before?
Yes.
Here, right there. Okay.
And I guess I will print off all the texts and all the phone calls, but can I ask one question?
Yeah, sure.
Is there any way that phone communications can be recorded between me and her?
Well, you're already supposed to be using this app, weren't you?
But see,
That's
but
the only
problem
way you're
is-
supposed to communicate.
Okay, but that's the problem. When she grabs my daughter's phone and calling me everything I call her in a text, she's not getting in trouble for it. But I am. But I've got a witness sitting right back there who's heard everything she said. And I've got other witnesses that if need be, we can have another court and they can come. She knows. I mean, the calling of the names goes both ways. It does. And you told us both in that last court that we neither one is supposed to do that. That neither one of us.
The problem that you've got is there is a domestic violence order that tells you not to communicate with this woman about anything other than the children through the app.
Right.
Or if there's an emergency, you can communicate with it. But you've been doing that.
Okay.
Now, wait, what do you think I ought to do about that? You're just ignoring the order and then saying you can't hide behind the judge and stuff like that. I mean, I think I've been pretty liberal with you. I've never put you in jail yet, you know, and I've tried to let y'all work through the things and everything.
I've
But,
tried.
you know, but the thing about it is I cannot ignore you continuing to say these things and communicate these things. Sometimes, even though you want to say something, you're just prohibited from court orders from saying it. And you cannot be communicating with her about things. You can't talk to her. You can't send these texts. And as far as these things that you said to the children about mama sending me to jail and all that kind of stuff, that's bad stuff right there, man. To say to a child.
Yeah. Well, my child's come in and tell me the things she says, but I mean.
Well, when a child comes
So
and
what am I
says
supposed to
that,
do?
record it. But you don't need to be threatening your children and saying, mommy's going to send me to jail and I'm going to cut you off if you're not going to stand up for me. That's trying to influence them.
And I asked my child the other day, I said, do you all want to do this? Do you want to do this? No, because mama will get mad. Mama don't want us to come see you. That's coming from my children. And I try to get along with the judge. If you looked in Texas where it starts at, it's a simple, what are my kids doing? What are kids doing?
You're not supposed to text her and ask for what your kids are doing. You're supposed to use, did
I
these
did.
come off of that?
Yes,
Did these
I
come
did.
off of the thing,
I did. And her response is, just for the last week, was, you cannot contact him. You're supposed to contact, my children are supposed to make the call. My 5-year-old cannot make a call.
What do you have to say?
Judge, I would just ask that the order of arrest that's been issued be put into place because obviously nothing is getting Mr. Roach's attention. And I'm not trying to be drastic at this point, but he's had opportunity after opportunity after opportunity. And it's clear that he does not have any respect for the court orders that are in place. And it doesn't appear that he has respect for his children in this circumstance.
Your Honor, I have all kinds of respect for my children. I do anything for them. I call them every day to tell them I love them.
Well, I'm going to extend the EPO for 3 years, as long as I can extend it. Okay. There's an arrest warrant out for you now. I don't know what to do with him, man. I really, really, really hate to put you in jail.
I just want to be daddy, Your Honor.
I really hate to put you in jail, but it just doesn't appear to me that you're going to be able.
I won't be able to pay child support or nothing. No.
Well, I know that, but now.
I lose my job. When I lose my job, I mean, if I go to
Well,
jail.
yeah,
I lose my
but
job.
here's the thing about it is, you can't, I don't want you to lose your job.
I will. If I
I
go to
don't
jail.
even, look, I don't even know you. But I respect you. Okay, I respect everybody that comes in. I respect you because you work, you know, and that sort of thing. So I don't have anything against you. Okay, but you got to follow these court orders, and you get carried away and mad, and people get done. I've been mad. Everybody's been mad.
Everybody says stuff they don't really mean, and just.
Yeah, well, that's the reason we have these EPOs.
Okay,
in place.
but how come she can say what she wants to me?
Why are you doing talking to her?
But she's texting me out of the blue. I mean, but I don't go through my phone trying to.
Are you
put her in
texting
jail.
him?
We can
Not
find some.
out of the app, everything's in the app, and I don't text anyone, it's
No.
regarding something with the kids.
Every contact is in the
Won't
app.
no contact.
Every contact is in the app.
I don't
Wait
want-
just a second.
I know, what he's referring to is, yes, I have took the phone away from the kids and hung up because he's starting in and I can hear him, and I'm not doing it. If I can hear that at my house and I have my children, they're not gonna do it if I can stop it. They're not gonna listen to it.
At my house, Judge, can I stop it?
Stop what?
If she starts in? Can I?
Start saying
Okay.
what? What
Here-
are you talking about?
With the kids.
I don't know what you mean.
Okay, when she calls my daughter.
Here, let me tell you what we're gonna do. We're not gonna do that here today. But in this larger case that we have, that we're gonna do, we're gonna talk about what you said and she said and what everybody said, and we'll get into as much as you want to. This situation here is about the emergency protective.
Can I ask one question about the emergency protection order?
Sure.
What does it say about her coming to my house, showing up at my house?
The emergency protective order is against you.
Okay, I'm at home.
Oh, well, okay, and the emergency protective order, if she comes to your home, you should call the local police.
She's been there 3 times in the last month.
Well,
So that tells me she's not too worried about nothing.
have you been to his house?
Only because he says it. Because when it was time to pick up the kids, I had to be in Salina anyway, and I said, I'm gonna be in Salina anyway. If you want, I'll come out and get them, or you can meet me in Salina where I'm gonna be at the Mexican and drop them off. He said, come by my house. If you say so. So I did. And yes, it's my house. You can see it.
Yeah. So to me going to jail and her showing up at my house, I just want to be daddy, Judge. I don't want no contact with her. I don't want no contact with her mother. I want my rights to be daddy and be able to talk to my kids how a father should be able to.
Yeah, well, you're not talking to him how a father should be able to talk to you. When you say daddy's going to jail and your mama's trying to send me to jail, I mean, that's enough to put you in jail right there.
So, but the bruises and her kicking my child out is not enough to put her in jail?
We're talking about what you're doing.
Okay.
Okay, if she's doing something, you can file a separate action.
Where can I file that at?
Well, wherever it happened.
Okay.
You know, you can file anybody's got a right to make any kind of allegation. You can go to social services if something happened down in
Okay.
Tennessee. You can go, if you think it happened in Kentucky, you can go to social service. You can spend the rest of your,
Okay.
you know, you got a complete right to have access.
Okay. And what about?
I'm sentencing you to 7 days in jail. Okay? And for violating the domestic violence order. Okay? Now, today is on the 30th.
Can I do them on the weekends?
I know. No, you're going to jail today. You know, and you're going to jail for 7 days today. And the next time you violate one of these things, I'm going to find you in contempt. I can give you up to 6 months. I'll give you 6 months in jail. Now, I don't want you communicating with him verbally or anyway. If the children are talking to him on the phone, don't be there. Okay? He's not under an order right now where you have to listen. Okay? And I know now I can see from some of these things right now. But if we have one more instance where either one of these children say that you have said anything derogatory about her, her family, or anybody else, then you're not going to be able to talk to the children unless it's monitored by someone else. I'll have someone monitor. I do not want to take you away from those children. I want you to keep in contact with them. I don't even know, are they in school here or were they in school?
Both of them are.
Okay. But I do not want to take them away from you. I do not want to interfere with that. But you cannot violate these orders on these. Somebody's going to get hurt. I mean, she's got people in her family. You got people in your family. There are people that get killed over this stuff. When these people say this stuff to each other. You know? Okay, we'll take him into custody. Okay, now the EPO will be extended for 3 years. Thank you very much. Court's adjourned. Who is this lady here? Take her out of the courthouse now. If you say anything else, you'll be joining him up. You cannot ask to talk to a judge or speak to a judge or talk out in the courtroom like this.
You have to have an appointment next week, correct? Yes. Okay. But I didn't think so.